We will call the special commission meeting for March 2nd to order. We'll stand with it for a moment of silent reflection. Pledge of Allegiance led by Commissioner Farabee.
Thank you. I pledge allegiance
to the flag of
the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Welcome to this meeting. I hope any and all of you that got a copy of our format for this evening's meeting. I'll just quickly go through it. 5 minutes speaking time per individual. And individuals we've asked you to sign up if you do wish to speak. And if you've signed up and someone ahead of you says something that you were going to say and you choose not to repeat it, you wish to yield your 5 minutes to them, you can do that. Just state your name and say, I yield. Holly has the sign-up sheet, and I think we'll call you up in the order that you have signed up.
Is there anybody else in the room that wants to speak that didn't get the opportunity to sign up?
Okay, we can stay here for as long as you have something you want to share. In other words,
There's a lady right there.
We're not going to set a time limit for holding this meeting, but there will be equal time given to opponents and proponents. And the opponents will speak first, and Grow Ready Mix will speak second. Once we've gone through the public testimony, we will close the discussion, and it will be restricted to the commission itself. When you're speaking, we're rather than have someone from up here ask you a question during your speech, we will make note of the question and call on you with that question when everyone's done speaking. And that way we don't get into a debate during your 5 minutes. Once the commission has closed the discussion, then the board will deliberate, and based on a motion, will make either a final decision or continue the appeal in order to gather additional information or to answer questions. And we're going to open the meeting with a commentary from Planning and Zoning and from our state's attorney to identify the purpose of this meeting.
Okay. PJ Conover, Director of Planning and Zoning. Item number 5 is appeal hearing from Planning Commission and Planning Director's approval of construction permit CP 1517 Kroll Ready Mix Incorporated to continue operating the active Pearly Quarry as a rock quarry and to expand the current area of disturbance. Just for the record, there's 4 purposes in construction permit section 507A, and I'll read them into the record. We do have a handout for you as well, and I do have an exhibit to bring up after the presentation. The purpose of section 507A is to establish minimum stormwater management requirements and controls to protect and safeguard the general health, safety, and welfare of the public residing in watersheds within Pennington County. Section 507A seeks to meet that purpose through the following objectives, and there are 4. Item 1, minimize increase in stormwater runoff from any development in order to reduce flooding, siltation, increases in stream temperature and stream bank erosion, and to maintain the integrity of stream channels. Second objective in this section is to minimize increases in non-point source pollution caused by stormwater runoff from development, which would otherwise degrade local water quality. Objective number 3 in section 507A is to minimize the total annual volume of surface water runoff which flows from any specific site during and after development so as not to exceed the pre-development hydrologic regime. And item 4 in section 507A, reduce stormwater runoff rates and volumes, soil erosion and non-point source pollution wherever possible through stormwater management controls and ensure that these management controls are properly maintained and pose no threat to public safety. So those are the purposes of section 507A that our staff is bound to look at and adhere to when we're approving construction permits. In addition, construction permits are also under our Pennington County Stormwater Quality Manual, which I'll have an exhibit for in a moment. And the Stormwater Quality Manual, the criteria was developed to help mitigate the increased soil erosion and subsequent deposition of sediment off-site during the period of construction from start of earth disturbance until the final landscaping and stormwater quality measures are effectively in place. There are performance objectives in the Stormwater Manual. The objectives for erosion and sediment control during construction include the following. Conduct all land disturbing activities to effectively reduce accelerated soil erosion and reduce sediment movement and deposition off-site. Number 2, schedule construction activities to minimize the total amount of soil exposed at any given time to reduce the period of accelerated soil erosion. Item 3, establish temporary and permanent cover over areas that have been disturbed as soon as possible after final grading is completed. Item 4, design and construct all temporary or permanent facilities for the conveyance of water around, through, or from the disturbed area and to reduce the flow of water to non-erosive velocities. Item 5, remove sediment caused by accelerated soil erosion from surface runoff water before it leaves the site. And the last objective, stabilize the areas of land disturbance with permanent vegetative cover or stormwater quality measures. So when our staff is looking at construction permits, those are some of the things that we are bound to abide by. On November 15th, Kroll Ready Mix Incorporated applied for a construction permit which became known as Construction Permit 1517, and we have a handout for that coming up here in a minute. And while she's doing that, I'll get the 3 exhibits we just talked about. Okay to approach and put these exhibits in?
Thank you, PJ.
Thank you.
Good evening, Brittany Molitor, Water Protection Coordinator. And I want to kind of go through the process that I go through when I look at these applications after they are submitted to our office. I basically review these applications for completeness. There's a checklist that goes along with these applications. I ensure that all of the stuff that is supposed to be submitted as part of that checklist are submitted. I look at the type of disturbance that's going on as part of the construction. A disturbance in our ordinance is defined as any type of activity that involves grading, clearing, moving topsoil, rock, or any other natural surface from the property, which includes bringing in fill material to the site. I look to see if that type of disturbance is allowed in the zoning district on the property that's being proposed for it to happen. In this case, the site is zoned General Agriculture District, and in section 205B, 16 and 17, mining or removing of aggregate is a permitted use in that zoning district. Then from that point, I go and I route the request to other agencies that may have interest in this activity and other departments for comment. And once I get those comments back, I perform a site visit. I did on this case with the applicant, and I prepare a staff report. In this case, there is some concurrent jurisdiction with DENR. They do have jurisdiction over stormwater also for any disturbance over an acre. In this case, they were issued an industrial stormwater permit from DENR. After I prepared the staff report, the reason this request didn't go to the director for approval was due to our stormwater plan requirements. In our stormwater plan, we do require that the planning commission review construction permits, and there is an exhibit of the stormwater plan for the record. And so that is what I recommended. So when I go through that, I recommend different conditions. And these conditions pertain to what we are bound by in section 507A. They typically pertain to erosion and sediment control and stormwater. And then other agencies' criteria for approval, all I do when I route that is I ask if they have the permits needed for this kind of activity. Once I receive that information, I move on. It's part of the checklist. What the agency's criteria for that approval, that would be up to that specific agency for their requirements. Some of the agencies are here tonight, some of them are not, but I have spoke with some of them. They can be available upon request of the board at a later date.
I'd like to bring up Exhibit 4, if that's all right.
Thank you.
Just a little bit more. After receiving the construction permit application, which turned into construction permit 1517, it was first heard by the Planning Commission on December 21st, 2015. It was continued until February 8th, 2016, due to a Planning Commission motion because they wanted further comments from Department of Transportation, County Fire, Rockerville Fire, and also to allow the citizens time to review and understand the application. On February 8th, 2016, the second time the Planning Commission heard construction permit 1517, the Planning Commission approved CP 1517 by a 4-to-1 vote. It was, and we have another exhibit that'll bring up in a minute that has that staff report and all the applicable handouts, which you actually have a copy of for the packet today, but just like to put it in as an exhibit. In addition to that, another presentation was given by Barrett Went that was given to the Planning Commission. Not sure if it was handed out, but that's also going to be Exhibit 6, which we'll bring up to you, and we have a handout for that coming from Cassie. After the Planning Commission's decision to approve CP 1517, as a director, I wrote a memo affirming the Planning Commission's decision as per the requirement. And 2 days later, on February 10th, an appeal was received by the Planning Commission office staff Commission office staff for CP 1517, which brings us to today.
Okay, thank you.
You're welcome.
Jay?
Good afternoon, Commissioners. Jay Alderman with the State's Attorney's Office. Commissioner Buskerud, can you hear me okay?
I surely can.
Thank you. First, I just want to thank the Planning Department, PJ and Brittany, for laying out, summarizing very nicely the process from applying for a construction permit through the process of review and narrowing down the various roles or agencies or entities involved in reviewing the permit and its ultimate issuance or granting. That's important because one of the things I want to emphasize tonight with regard to that is that very separation of responsibilities and review. Clearly from 507A is the guideline. It's the rule, it's the law for Pennington County to follow on receiving an application for a construction permit and for the Planning Commission, the director, and ultimately this body to review it. And what I want to emphasize in that regard is that in 507A there are different agencies that have some involvement, particularly DENR. And you heard from Brittany specifically about their involvement with their stormwater plan, I believe, and the mining license, Those are those agencies' separate matters. They're not for this board to review those matters because that's their agency's license or permit or plan. Also, I know there's been reference to the Department of Transportation. I do believe there's a representative in our audience tonight from DOT. In routing this, the review of this license among the agencies, DOT naturally received that. And their purview or their jurisdiction is obviously State Highway 16. And so they have the jurisdiction and the authority to review matters with regard to traffic on 16, safety issues with traffic. That's their bailiwick, if you will. That's their purview, not again this body or the commission or the planning department. So the focus of tonight's hearing with regard to the review by this board is with regard to the stormwater discharge issues, sediment erosion controls, and dust control. And if I've missed anything, PJ, I'd ask you to correct me, but those are the focus of what this board ultimately has to base their decision on, not the focus of DOT's issues or DENR's separate legal issues. As far as procedure and evidence goes, last year our legislature passed a law that I want to share with you. First of all, the law basically speaks to this kind of a hearing that we're having tonight. We refer to it as a quasi-judicial hearing, meaning that you are not the Supreme Court, you're not a circuit court, so your general duties are not court duties, but you sometimes act in a quasi-judicial matter, such as a hearing like this, where you're taking evidence, you're reviewing decisions of, in this case, the Planning Commission, the Planning Director, or the Planning Department. And the law makes it very clear the formal rules of civil procedure and evidence do not apply to this proceeding. So you're not bound by the strictures of what we would face in a courtroom. People coming up here aren't being put under oath and subject to cross-examination, and the rules of hearsay don't apply, and there's many, many, many more rules of procedure and evidence that if you were in a courtroom or you were presenting to the Supreme Court, you would be bound by. Those don't apply here. But one of the things we've talked about that is kind of a logical thing we should do here tonight, and that is, you've seen Holly and I gathering the documents that are being marked as exhibits. It's important that we obviously have a recording of these proceedings and that we mark exhibits. So when individuals come up here, they clearly identify themselves. They identify if they're bringing a document with them, they identify that so that we know who they are. We can, if you had to review it on audio or video, you'd know who that person was. We will mark their exhibit and it will become part of the official record. And I'm certain there will be individuals tonight that will be bringing you those things. And it's good that we're doing that, so I wanted to make sure that everybody realizes why we're doing that and the purpose behind it. The other thing I wanted to bring to your attention is part of that law talks about public disclosure of evidence. And it specifically speaks to the five of you as officers of the county in a hearing like this. And I'll just read from it. The formal rules of procedure and evidence do not apply. If any officer relies on any evidence not produced at a public hearing or meeting, the officer shall disclose the evidence publicly and include the information in the public record to afford all parties an opportunity to respond or participate. What that means is that if you yourselves, and there's an additional statute that says you are absolutely free to garner information on your own. People can approach you, your constituents, members of the public, both for and against the permit at issue here, and talk to you. There's nothing that forbids that. And you are expected to use your own objective viewpoint to not be biased and so forth. It speaks to that. But if there's evidence that you've received, whether it be evidence can be oral or documentary. So it can be written or oral. So if you've had communications with either side specific to this issue, or if you've received documents from either side specific to this issue that you might rely on, You should disclose those and probably disclose them tonight to the best of your ability, and we will also mark them. If you have a copy, if you don't have it on you, we'll get a copy of it and make sure that that's part of the record to comply with the intent of this statute. So if you've had communication, probably even with the state, DNR or DOT, and they provide you documentations or a copy of a permit or something like that, we can mark that as an exhibit and have that. It's just about public disclosure so that the whole world knows what you know and what you might rely on in making your decision. Ultimately, well, and I guess if there's any questions on that, stop me and I'll try to answer them. But ultimately then, you will make a decision. And your options are fairly straightforward. Your options, certainly you could move to affirm the issuance of this license or the permit. You could move to deny. You could also take some interim action. There may be provisions in 507A that you think you need more information on, whether it be from DENR is not here tonight, a representative, but they could be, and maybe you need to hear from them on something just so they could explain their process or their permit. You could delay this matter to another special meeting where you could get that information. You could also direct the planning director, if there's some provision of this section of 507A that specifically applies to the county's jurisdiction, to vet that out or come back to you with more information on that, whatever that might be as the night progresses. So those are your options. I think you're probably already aware of those, but I just wanted to repeat them for the record. So I don't think I have anything else specifically.
Okay. Thank you.
Thank you.
We'll,
Mr. Chair, we do have some mining information that I requested, the permits for, and from Planning Department that have all the permits and on Kroll in this documentation that all the commissioners should have, and we should put it as a documentation, so. Yeah. And Holly told you about that ahead of time, Jay, so.
Thank you.
Thank you.
okay, any other disclosures? If not, we'll proceed with public testimony, and Commissioner Hadcock has compiled things here to where I will just let you call up speakers, if you would, please.
And Ms. Holly will tell them when it's time, sir?
Yes.
Okay.
Can I have just a minute?
Go ahead, Ms. Holly.
I just want to let everybody know that the timing system that the Board of Commissioners uses, there's a light box in front of the chairman. The red is obviously time. It'll flash green when it's time for you to start speaking. We always ask that you approach the podium and identify yourself. Yellow light will flash when there's 30 seconds remaining on your time. For the individuals that have already organized and have yielded time to others, I don't want to keep continually interrupting you because our timing system only goes in 5-minute increments. So I'm going to use my phone and I will just interrupt you when there's 1 minute left to go, and we just ask that you wrap up your comments.
So I'm going to ask Commissioner Hadcock to read the names and of the people that have yielded to a speaker so that you understand that they may have more than 5 minutes. So would you do that, please?
Want to do it while they're doing it or now? Now?
Go ahead and call them up.
Okay, I figure we could just do it and then tell the people that, okay. So Barrett Wentz, you're up for 15 minutes. Karen Wentz, if I mispronounce her name, I apologize now. Karen Wentz, Pete Mazzella, Nancy White, and Nancy White, those three yielded to Barrett, so he gets 15 minutes. So Barrett, you're up. What's that? Do you need more than 15 minutes?
I should be fine.
I didn't think so, Barrett. Okay.
Where is my?
State your name, please. And
Yep. My name is Barrett Wendt, and I'd like to thank the commission for hosting this meeting tonight, allowing me to present on this very important topic.
Excuse me,
Yes.
Mr. Chair, would you want to pull that a little closer? I can see people trying to hear here.
Sure, you bet.
There, that way.
a short lead.
Okay. No, I can just move it back, that's fine.
And folks, if you have a packet that you gave us, you can tell us so we can follow along, because some people do have packets. So if you're speaking and you do have some presentations, whether it's Kroll or the neighbors and the people in the audience, please tell us so we can follow along as well. That'll be helpful. Thank you.
And just for reference, you do have the packet I will be presenting on, so thank you. And I'll start over since I was quiet. My name's Barrett Wendt, and I'd like to thank the commission for scheduling this separate meeting tonight and allowing me to present on the very special, important topic. And others have ceded time to me, so my presentation should take about 10 minutes. So there are many concerns about the expansion of this mine, and I echo those concerns. Am I too loud? Safety of travel on Highway 16, impact on tourism, air quality and erosion control, impact on existing businesses and residential properties, impact on future development, potential impact on existing water wells. In previous meetings, we heard about the 1980s when this mine was first opened, so I looked up some changes that have occurred in Rapid City since that time. Population increase of 59%, Mount Rushmore tourism increase of 130%, Sturgis Rally attendance increase a staggering 1,200% in 2014 and over 2,400% in 2015 for the 75th anniversary. So the original mine may have been the right decision in the 1980s, but that doesn't mean the expanded mine is the right decision today, especially in this area. There's one word I think of when I see these changes, and that's growth. I think it's safe to say that this growth will continue over the next many years, if not significantly increase, especially along Highway 16 near this mine. Some existing businesses in the area, I won't read them all, you're familiar with them: Independence Hall, Bear Country, Reptile Gardens. All of these businesses are driven by tourism and are critical to the economy of Rapid City and to Pennington County. I think it's important that we talk about growth in these businesses and tourism because of the requirements in Title 11. It's probably one of the most challenging for this commission in that you need to verify the decisions you make, support the comprehensive plan, and protect the tax base. So this is a picture provided by Kroll of the enhanced mining area, and I'd like you to notice the shaded red area labeled future disturbance. And I'm sorry you can't see that in the black and white picture I provided. This is a simulation of what that mine might look like at full operation. So how will this impact these businesses we just talked about? How will it impact the taxes generated from those businesses? How will it impact property values around this area? How will it impact future development in this area? How will it impact tourism? You do have the authority to and the responsibility to control this activity. Section 507, as it's been stated before, the construction permit, Section 507 is not intended to interfere with, abrogate, or annul any municipal ordinance, rule, or regulation, statute, or other provision of law. The requirement, and furthermore, the requirements of 507 should be considered minimum requirements. Furthermore, whichever provisions are more restrictive or impose higher protective standards for human health or the environment should be considered to take precedence. Clearly, your authority is not limited to Section 507. This leads us to the authority you have and have been granted in Codified Law 11 for county planning and zoning. This commission has all such powers necessary to perform its functions to promote county planning and zoning. Temporary zoning controls can be established to protect public safety, classify and regulate uses and related matters. Zoning ordinances can be established to promote health, safety, general welfare, to regulate and restrict land for for trade, industry, and other purposes. Zoning districts can be established to regulate and restrict the use of land. This is a busy slide, but when regulations are established, they should be in accordance with the comprehensive plan designed to lessen congestion in the streets, secure safety, and considerations made for the character of the district, conserving the value of buildings, encouraging the most appropriate use of land. We should apply these same criteria to the Kroll request. Does it align with the comprehensive plan? No. Does it lessen traffic congestion? No. Does it fit the character of the area? No. Does it conserve the value of existing buildings? No. Is it the most appropriate use of land in this area? No. This request does not meet any of these criteria. Simply put, a large industrial operation in this location doesn't make sense. So as Title 11 recommends, zoning districts have been established, and I'd like to review two of these. Section 212 is heavy industrial. As it states, the intent of heavy industrial district is to establish areas for necessary industrial uses that require isolation. Permitted uses include rock, sand, gravel, or other earth excavation, crushing, or distribution. Section 205, an A1 general agriculture. As it states, the intent of A1 general ag is to support and encourage agriculture. We should also reference the definition of an agricultural operation as defined in Codified Law 2110. Agricultural operation includes any facility used in the production or processing for commercial purposes of crops, timber, livestock, etc. How does a mine this size, that covers over 80% of the total property, meet the intent of general ag zoning, which is to support and encourage agriculture? How does it comply with the definition of an agricultural operation? As further evidence, we need to look at the information Kroll has provided about the expansion of this mine. This is a copy of the description of the construction permit request filed by Kroll in December. Their own words in this description suggest that the activity should be contained in a heavy industrial zoning district. Rock, sand, gravel, earth excavation, crushing, or distribution. This activity does not support and encourage agriculture. This is a copy of the water permit request submitted to DNER in January for industrial use primary. This highlighted yellow on the picture, and you can't probably see it on your copy, is the land Kroll was attempting to rezone heavy industrial last June. As you can see, this property would have adjoined with the property they now own. With this action, Kroll further demonstrates that their planned activities for this location are heavy industrial operations. This mine does not belong in this area's zone general ag. However, we're all here, didn't mean to yell at everyone. However, we're all here because the property in question is currently zoned general ag. One of the permitted uses, as stated, is mining, provided a construction permit is obtained in accordance with these zoning ordinances. The last portion of this statement is very important because there are two parts to 507. 507 Part A and B. We tend to continue to skip B. So Part A, a construction permit is required for excavation, clearing, land distribution greater than 10,000 square feet. There are some exceptions, but I don't think there's any argument here. None of these exceptions apply. Kroll needs a construction permit for this location and has applied for one. Another long paragraph here, section 507, Part B. As it states, no extraction of any mineral or substance should be conducted without a mining permit issued by the Commission. Language is very clear. This permit is a written order from the Board of Adjustment in the form of an administrative review, conditional use, or variance. Information that must be provided: a site plan, transportation plan, scope, duration of the mining activity, and a reclamation plan. The only exception for a mining permit is for construction that is agriculturally related. This exception does not apply. I ask the Commission to fully enforce the requirements of Section 507B as it relates to this request. And lastly, I feel it's very important that we continue to focus on the intent of General Ag District. We already know from previous slides that the intent is to support and encourage agriculture. I believe that the stabilization requirement in Section 507 supports this as well. As it states, final stabilization must be completed within 1 year of project completion or 2 years from the construction permit issue date, whichever occurs sooner. This clearly shows that the intent of the construction permit as related to mining activities is not intended to support a heavy industrial mine that plans to be in operation for over 30 years. I see nowhere in Section 507 that this requirement is exempt or can be waived. So in closing, I've addressed many concerns with the enhancement of this mine. We've reviewed the authority of the Commission. We've raised concerns about the impact on growth and tax base. We've raised questions about zoning districts, reviewed the definition and intent of general ag. We've reviewed the timeline required for final reclamation. We've reviewed requirements in Section 507 and requested full enforcement of same. Using Kroll's own words and actions, they've condemned themselves. This is a heavy industrial operation and it does not belong in this area or this zoning district. We do not have the liberty to selectively enforce zoning regulations. I ask the Commission to deny this request and use the authority you've been given to fully enforce our zoning laws. Thank you.
Thank you. Jay, do you have a? Okay. Next.
Questions?
Oh,
Okay.
This
Thank
is
you.
just for you guys
Okay.
to speak first, and then we will have our time to speak after both the opponents and proponents have talked.
okay, call on your next one then.
Ready, Ms. Holly? Dwayne Abada, sorry. And yielding for Dwayne is Karen Abada, so he gets 10 minutes.
Thank you. My name is Dwayne Abata, and I'm a resident of Pennington County. I'm also a professor just down the street. I also have written the editorial in the newspaper published a few weeks ago on Kroll mining. And in that editorial, in the first paragraph, I stated that I was not against mining. I am not against mining. I actually am, is that ringing? Feedback?
It is ringing, sir.
Getting some feedback, yeah.
Don't get so close. I have actually been a department head of mining at Michigan Technological University for several years. So I support the mining industry. What I am opposed to, of course, is the location of this mine for a number of reasons. Location is one, and we've already heard a bit about the location. I won't reiterate. Patterns of behavior by Kroll, not only pertaining to erosion and dust, but about the entire operation. I'll elaborate a minute on that. The effect on residential water, and we have a speaker to talk a little bit about that. The effect on traffic, more importantly, the effect on traffic on a scenic route to our national monument. I'm here to talk to you about erosion and dust mitigation, and then a little bit about a potential storm. Whoops, I should know that. There we go. We've all seen this in the newspaper, front page. I need not elaborate, but to say that the corporation, with your approval, operates in Pennington County and does have a significant previous and recent record of violations. There are many more documented violations in other states, Kroll operates in 5 or 6 states. Note that many of the violations are very difficult to dig up, but we found quite a lot. In the first, one of the documents I handed out to you is entitled Talking Points, and on the second page there, I think it's the second page, lists all, as many violations as we can find anyway. So let's move on to photographs along Highway 16. The site now has been operated by Kroll for 3 or more months. One would expect that if your daughter or son wanted the keys to the family car, they would behave as near perfect as possible. Kroll has not. Well, Kroll has cleared a sizable acreage over the past 3.5 months or so. They have continued with their past less than stellar behavior. Here are some obvious examples of soil erosion caused by the mining operation. And I bring your attention to the slide. This is the roadway, Highway 16, the ditch on the left-hand side, significant erosion. On the right-hand side, there has been some gravel that has been tossed up and is indeed a safety hazard for automobiles and also most certainly for bicycles and motorcycles, of which we have hundreds of thousands, I believe, come here every year. The next slide is a picture of their access road to Highway 16. And you can see by the circle there, erosion is prominent, has not been addressed, and continues, even though you can see in the background the property has been cleared, ready for the mining operation. Now, what are we going to expect? This has just been small aggregate mining up to this point. Let's take a look at what has been happening in the past and what may happen in the future. This is a list of the tonnage of aggregate taken out of the Pearly Pit. And if you add them up, you can see at the bottom corner there, the average tons per year, roughly 19,500, or let's just say 20,000 tons per year, over a 32-year period. Now shift to the right side of the slide with the tons per truck at 10 or 20. I understand these are still relatively small trucks. Tons per day, 150 trucks per day, and that comes out of a statement that Kroll made. I did not make, Kroll did. If you add them up, you come up to close to 400,000 tons for a 6-month period, or close to an 800,000 tons over 1 year. Compare 20,000 to 800,000. I would not call this agriculturally related. Zoning will become, my little note up on the upper right-hand side, will become a de facto heavy industrial zone. Now let me move on to a video that was taken by an astute observer that had the foresight to bring her camera along and record this event. Start the video here. It's about 2 minutes long, so bear with me. You can see you're up on a ridge, and Highway 16 is on the left-hand side. There's traffic on the left-hand side. We're overlooking the mining operation. This was taken on February 10th. February 10th is what, 20 days ago. And in a minute, you'll see the blast, less than a minute. There's the blast, and you can see what happens. And remember, this is done by Kroll. This is a small operation up to this point. And let's take a look at that dust mitigation or absence of dust mitigation. That is deposited on the other side of Highway 16 and flows all the way to Hart Ranch area, across Neck Yoke, and literally poisons the land, filled with dust, very difficult to breathe, etc. That was just one small blast. We actually recorded 3 blasts. I'm not going to show all 3. They all look the same. This is a heavy industrial operation. There's no question about it. Multiply this dust by the tonnage on the previous slide, and you've destroyed all that land downstream. Now, the wind happened to be blowing that particular day west to east, as it usually does, but it does blow north to south. It does blow west to east, east to west, all different directions. So you can envision a whole area, circle around this heavy industrial operation poisoned because of this dust. So I request, of course, a denial of the permit based upon behavior, based upon what you've seen. If a denial is not made, I request a postponement because the DENR water permit application, which is a critical component of the decision, has to be included in the decision process. And also, it allows time for the county commission to further examine the existing codes and laws, as Barrett just discussed. The interpretation and enforcement is intended by the residents of this county, in particular Pennington County Code Section 501A and B. I also ask that if a postponement is considered, and in light of the slide you just saw, the video you just saw earlier, and the erosion, all work must cease until a final decision is made. We cannot count on the goodwill of the company that's trying to set up heavy industrial operation here in an agricultural zone. Now let me take a brief moment in my concluding slide to explain to you the tempest before a possible storm.
1 minute.
If this decision is to move forward to approve this so-called construction permit, there are people, residents among us that believe that the decision before you is in fact a request to violate county code and is a de facto rezone. We all know that this corporation has deep pockets, deeper pockets than you or I. Here is a team of lawyers specialized in legal challenges of this type, and they will use every phrase and every word to get what they want. We know this to be expensive. We do not have this luxury. What will happen in the coming months is that I anticipate professional fundraisers will take over to help raise funds to defend de facto rezoning from agricultural to heavy industrial. They'll be needed to fight the legal fight. You'll see advertisements, journals and magazines soliciting donations. National Geographic, Outdoor Life, Smithsonian, and also in those magazines you find in the front pockets of the airlines. Thousands of dollars, hundreds of thousands of dollars are needed to continue this fight.
Time.
And this is a simple case of zoning gone astray.
Time.
My entire paragraph in there, but that's how it's going to be.
Okay, thank you. Next.
Next speaker is Michael Mueller, and yielding their time is Pat San Martin and Beth Mazzella. So, Michael? You bring your water?
Brought somebody else's water.
I know.
Good afternoon. You do have a handout for my slides. I'll move this over here because I think the feedback's a little bit better. My name's Mike Mueller. I live at 23764 Wallace. That didn't help. So. Okay. Okay, I come before you as the District 3 Director for West Dakota Water Development District. I'm also a mechanical engineer, been in the construction industry for 30 years, and I'm also a concerned citizen in the neighborhood. This slide represents a few of the wells surrounding Kroll's development. They are commercials and municipal wells. There are some residential wells. That does not work. That's not very big. I'm going to put this bigger here. In your packet, there are some statistics. As engineers like math, some of this information was derived by another engineer, as a friend of mine, living in the neighborhood. And the request on their water permit asked for 6.4 million gallons a year. Divide that by 52 weeks, you've got the math in front of you, approximately 51.2 gallons a minute at an 8-hour day. Now, the potential, at the rate of what they're asking for, could build all the way up to 18 million gallons per year, which would be 3 times their request, if you follow that math through those equations. It appears that Kroll has a potential to draw water 3 times what they've asked for. And if that's an industrial use, and it's a drawdown on that aquifer, if you look in Rapid City, the average daily use of a person's water, you'll get to the bottom line and say that's an equivalent of either somewhere between 35 and 102 families that would be drawing that much water. That's a significant amount of water. And there are 150 wells, personal wells around this area as well, in addition to what's showing on that graphic. As we look at the property code, it does show as agriculture. We've all known that, we've all seen that. So it's from the equalization office, right off the sheet. The sale of the land, et cetera, is listed there. Here's a crop from the water permit. As we look at that, it's a new request. It also shows industrial use as primary. There is the 6.4 million gallons annually, equivalent volume of 100 families plus. And we have a review at the very top of that slide in Pier. It would not happen until May 4th or 5th, or could be postponed to July 6th or 7th. I don't know how they do dust mitigation without this water permit. If you take that into account, those should be your dates before you make any kind of decision for this permit. That slide you see before you is a real book. Some of the information we're going to share down the road here comes out of this USGS Atlas. Talk about radon. As we all know, is not a very friendly substance. If you look at some of these slides, maximum concentration levels are established for constituents that may cause adverse human health effects, which is enforceable by the US EPA. And radionuclides are unstable isotopes that are known to cause various types of cancer. In the Deadwood Aquifer, more than 30% of the samples analyzed for radium-226 and radium-228 exceed the MCL maximum concentration level of 5 picocuries per liter. Another part of that is that 90% of the samples exceed the proposed MCL of 300 for radon states without an active indoor air program. The Deadwood Aquifer, which I forgot to highlight in that permit, is where this water is being asked to be taken from, has a fairly high residual of radioactive substances. You have principal deterrents of the use of the water from Deadwood are high concentrations of radium-226 and radon. This shows a map with a zonal effect of if you look at the very top, levels of 300 to 3,000. And that arrow on the right hand of the slide lands right on top of the Kroll gravel pit and the Deadwood Aquifer. Dye testing has been performed between aquifers, and it has been shown that between the Madison and the Minnelusa, for instance, there can be transference of that water. The dye will go from one aquifer to another. As we know, these aquifers lay in between different layers of rock and et cetera in the hills. they can co-mingle, and mix, and you've got cross-flow potential in several areas. So if these two large aquifers can leak from one to the other, Madison and Minnelusa, what's the potential for the Deadwood to cross-contaminate another aquifer? Not a PowerPoint wizard, so I'm gonna go back and forth here. So stormwater discharge permitting for construction activities. This is the cover sheet on the permit. And a construction permit would probably fall under that. However, a construction permit, they're listed in their permit for industrial activity. So where's the miss? We've got something that's zoned agriculture. Income is derived from commercial and private sales of aggregate, and it's an industrial use. I decided to go look for permits on the website. So I put in, on DENR's website, I put in Kroll, Pennington County, just to find out what kind of stormwater permits they had. It came up with one industrial rated type. City of Wall municipality receives the stormwater. Thought, well, there's a copy of the permit. Permit number matches up on the top corner. So I thought, well, I'll go right to the property. I'll put the section, township, and range in, leave it as Kroll, leave it as Pennington County. And I'll see what they have at this property site. No records found. How's that? DNR not caught up to everything? But there's a letter that exists. And it says a stormwater pollution prevention plan must be developed and implemented. So I contacted DENR and asked them, where is that SWIP, as they call it? And they responded to me that they do not have a copy of it at DENR's office. But it's supposed to be on site at the mine. So if you see Stephen Perner's signature on that one permit, why don't we have a permit with his signature on it for this? Not sure why that is. Inconsistency, maybe our government's not catching up to everything that's happening. I'd like to have you ride along with me for a little bit of traffic information. If you go to, you can read that slide, 150 trucks per day, 8-hour shift, you've got 300 trucks episodes, which is about 1.6 minutes per truck on and off that property. So you take the northbound hill, a 2-minute climb, and average speed of 30 miles per hour. If you look below the slide, speed limit out there is 65 miles per hour, and I would bet to say DOT will not reduce that speed limit. That's a car traveling or a vehicle traveling at 95 feet per second. Takes a car 300 feet to stop at that rate of speed, a truck longer. Gravel truck takes 15 seconds to cross the road. And we've got the traffic rates that we have. You've got a car coming by there every 5 seconds. Well, you'll see in a later slide, average. I think we're creating ourselves a pretty big hazard. So if you have the geometry of that truck, side dump, for instance, it's about 52 feet long when you look end to end. You line that up on the road, that's a scale drawing of what that truck looks like pulling across the road. And I realize this is traffic, it's not talking about erosion control, but it's all related, folks. It's all there. And yeah, there's a tailgater in that car right there, but in the event that you've got a truck trying to pull across for 15 seconds or whatever it takes, you'll have to tell me if you think that's not a hazard. Here's a line of sight on the road coming up to that exit or entrance, whatever you call it, to the mine. And Rapid City website, there was an arterial safety study done a few years ago for a 3-year span of time. And there was an average of 6,200 vehicles a day right on this stretch between Reptile Gardens and Busted 5 Campground. There were 249 arterial segments studied for that 3-year period. This is the only rural stretch that made the top 10 in crash segments of the 10 they listed. You take 6,200 vehicles a day average in 3 years, you've got a ton more in the summertime, during the daytime, when traffic is heavier. 75% of your traffic is probably moving during the daytime. So if you take that number, the very bottom, that's where we came up with the 5 seconds per car, because you're probably 12 hours of daylight, 25% of it is in the dark, so you get 93 cars per hour, 300 cars per 12 hours. And you break that down, that's a car every 5 seconds average. So a lot of items that are related here, but I believe, got a sample here to show you from a gentleman who lives on Neck Yoke Road. And we have some water. He says he can feel the blasts at the time that they blast over there. And for 2 days or so, there's an after effect that he's got colored water in his well coming in. He didn't have enough warning to coordinate a blast, but this is his regular well water, and it's only gonna get worse. So, thank you very much.
Thank you. Thank you.
Let's see, next is Julie Witcher, CVB.
Thank you. I'm Julie Witcher with the Rapid City Convention and Visitors Bureau, here on behalf of Julie Jensen, Executive Director, and I am representing the Rapid City Hotel Business Improvement District Board of Directors. I just handed the state's attorney a copy of the letter that you all received via email on February 6th. It was sent to both the Planning Commissioners Committee and you all here today. And I will just read that letter on behalf of the Hotel Bid Board. Dear Commissioners, on behalf of the Rapid City Hotel Business Improvement District Board of Directors, we want to express our opposition to the proposed construction permit CP 1517 being requested by Kroll Ready Mix. With tourism being the #1 industry in Rapid City and the Black Hills, our concerns are based on the effect the proposed mining construction and expansion would have on the surrounding businesses, the aesthetic impact, the water supply, and most importantly, the safety of all travelers on this very important corridor, the gateway to Mount Rushmore National Memorial. The increase in the heavy truck traffic emerging onto Highway 16 daily, especially during the visitor season, is of significant concern. Mining and tourism have coexisted for years in the Black Hills, and we recognize the importance of the mining industry throughout the region. We are simply opposed to increased mining in this area, which is heavily dependent on tourism. We respectfully ask you to seriously consider all aspects of this requested permit, including the importance of the visitor industry and the safety of all travelers on Highway 16. Respectfully submitted, Tim Johnson, Chairman of the Rapid City Hotel Business Improvement District Board, and Julie Smith-Jensen, Executive Director of the Rapid City Convention and Visitors Bureau. Thank you.
Thank you.
Next is Michelle Thompson, Black Hills Badlands.
Hello, I'm Michelle Thompson, and today I am speaking on behalf of the Black Hills and Badlands Tourism Association's Executive Committee, who represents the Board of Directors, requesting that you deny the construction permit by Kroll Ready Mix to continue operating the active Pearly Quarry as a rock quarry and to expand the current area of disturbance. As an association representing the tourism industry in the Black Hills region, we are concerned about the effects the expansion and the likely increase in heavy truck traffic will have on our visitors and the surrounding businesses. These include significantly endangering the safety of our travelers on Highway 16, the surrounding air quality, and appearance of the scenic corridor from I-90 to Mount Rushmore National Memorial and into the Black Hills. Increased heavy truck traffic, sharing the same infrastructure as citizens and visitors, is one of the most worrisome dimensions of expanded mining along scenic Highway 16 for tourism in the Black Hills region. A study of visitors to South Dakota showed that scenery was the main motivation for visitors traveling to the state, with Mount Rushmore National Memorial being the second highest. Within this study, scenic drives were also the most popular activity for visitors while in the area. With 13.7 million visitors to our state in 2015, many traveling on the Highway 16 corridor, this expanded project could have a significant impact on the tourism industry and repeat travel to the Black Hills region. As proponents of economic development in the region, we would like to emphasize that we are not opposed to mining in the Black Hills. However, recognizing that this area is heavily dependent on tourism, we do not believe this is an appropriate location for increased mining to take place. We urge you to deny the construction permit in favor of keeping our travelers safe and our scenic Black Hills beautiful. Thank you for consideration.
Thank you.
Next is Reptile Gardens, and it doesn't have a name on it. If you could state your name, sir.
Thanks. Joe Meyerhauser, CEO and President of Reptile Gardens. Rather than state what's already said, I will just say that the board and stockholders of Reptile Gardens agree wholeheartedly with both the CVB statement and the Black Hills Badlands and Lakes Association statement. Our primary concern, two of them, one of them is traffic. Having been in that valley now for over a half a century, we've seen a lot of increase in traffic, as stated earlier, and a huge increase in collisions at the bottom of the hill, especially as traffic from Neck Yoke Road and Heart Wrench Road has increased. We've seen a lot of very, very bad accidents. So our priority and our concern is public safety. Also, our guests spend an average of 3.5 hours on our property. Air quality is also a very big concern. Plus, we have a lot of animals that live outdoors, and air quality can be very damaging to birds and reptiles. Thank you for your time.
Thank you.
Next is Lanny Newman. If I got your name right? You can restate it right if you'd like, sir.
I'm Larry Newman, and I just want to say a couple simple things. I don't think there's anybody in here, unless you live in a log cabin, that doesn't have a concrete foundation in your house. Your basement floor, your garage floor, your driveways. Practically every building built in Rapid City's got concrete in it. So where are you going to get the concrete? Get the aggregate to make the concrete. I don't think a person's imaginary right to a scenic view should trump somebody else's right to develop the mineral rights that they own. And as far as traffic goes, these tourists are the biggest traffic hazard in Pennington County anyhow. If you ride a motorcycle, you got to get to work in the morning. Thank you.
Thank you.
Thank you. Are we doing, we're just going down the list whether they're opposed or opponent? Because I thought we were going to do an opponent and then, so anybody that supports it will have you speak
Yeah.
after the people that are opposed. So I think I have, anybody else opposed besides Richard and Kyle? Is there anybody I missed that are in support of the mine?
No.
Okay. If that's okay, Richard and Kyle, we're going to have you guys, and anybody else that wants to, in support, that might have changed their mind, speak after everybody else that were opposed. And I think that's how we set the meeting up. Thank you, guys. So next is Brett Sutton.
Good evening, ladies and gentlemen. As stated, I'm Brett Sutton. I've appeared before the commission before and in front of the county commission, or the planning commission. I'll be brief with my remarks because there's a lot of people tonight. I'm here and along with my wife, Robin, who have concerns. We have, as stated before, a line of sight to this mine from where I live. is a direct line of sight. So the things you visualize today are things that we see quite often sitting on our porch trying to enjoy the beauty of the Black Hills. Who let the dogs out? You're not getting all the video, I'm just saying, you know?
Do you have sound effects with yours?
Yeah, all right, yeah. I got your attention. On my previous presentation, I, like a lot in attendance, was not specifically prepared with respect to the restrictions placed on that meeting. As such, you all know that I immediately sent you copies of my intended remarks to each of you. I asked at that time that they be included in the minutes of the session, and I specifically request that they be included in the minutes of sessions again because we still retain those concerns. But furthermore, since the last meeting of the Planning Commission, I've had the opportunity to research more fully the particulars surrounding drainage, runoff, and water. Now, I'm not a hydrological engineer, but we've heard from engineers earlier this evening here who made some very fantastic presentations. I just want to remind everybody of the importance of the Madison and the Minnelusa aquifers as major groundwater reservoirs and source for domestic and commercial wells in central and western South Dakota. Having said that, I would like to point out that a study of aquifer susceptibility in Pennington County, specifically the Rockerville Quadrangle, was done by our own South Dakota School of Mines and Technology and updated as late as October of 2015. In that study, they showed, quote, where the alluvial deposits overlie the Madison along streams, e.g. Spring Creek, where I live on, the susceptibility is high to contamination. It went further to state that the effect on the Minnelusa is medium to high susceptibility. I point this out having studied the drainage of the proposed site, which will flow from and into no less than 3 major runoff areas, all of which will eventually flow directly into Spring Creek. As I understand it, approximately a mile east of our place, my wife's and I place, on Spring Creek, there's a significant ground fissure causing a sinkhole where a good portion of the water goes directly underground. The flow of the creek during the high season reflects this. You can drive down there and see the diminishment from point A to point B. Any contamination of Spring Creek would visibly be devastating in and of itself, but more importantly, any industrial or silt contamination would have a potential devastating effect on our major water resources in western South Dakota. I thank you for your time.
Thank you.
Starts with a T and
Is
I
it
think
Wyatt?
Wyatt?
He
Trevor.
must be a doctor or a pharmacist the
Trevor.
way his handwriting.
I thought I had bad signature. I think that says Trevor.
I just type a lot more than I write. My name is Trevor Wendt. So I was going to just comment on the amount of tonnage and rock that comes out of the current mine. And that's already been covered, so I won't readdress that. But I will state that Crowley, on their first presentation to the Planning Council, did say that aggregate was easy to find in the Black Hills. So I wonder why, or, you know, it raises the question as to why this location is so critical, since if it's so easy to get anywhere in the Black Hills. That's really all the comment I have at this point. Thank you.
Thank you.
Jean Kostenbader.
I will yield. My comments and questions have been covered.
Thank you, ma'am. Elizabeth Saunders.
Yes, I'm going to yield to my husband, so he has 10 minutes.
Okay.
Sorry, we've not done this before, so I didn't know.
You're okay, ma'am. 10 minutes for Carl Saunders.
Yes, I'm Carl Saunders, and my wife and I live off Hart Ranch Road, okay? We recently moved to Rapid City about 1.5 years ago from a small community called Spring Bay, Illinois, just northeast of Peoria, Illinois. And Spring Bay is located on the east side of the Illinois River with huge deposits of sand and gravel. We were on the volunteer fire department for 11 years. That department was a combined department, firefighting and emergency medical services. My wife is an EMT and has been in that department, and I was a designated ambulance driver. The length of the river that we had on the district was 17 miles, and from the southernmost point to the town of Spring Bay was 10 miles. Within 3 miles south of Spring Bay were 3 large gravel sand mining operations. And this is almost deja vu all over again, because one of those mining operations wanted to buy a large parcel of land and increase the flow of traffic and trucks along the highway. I and a few other folks did some statistics, and we found that in the 17 miles of River Road, the southern 10 miles to the southern end, which was the Peoria end, had twice as many accidents, ranging from chips of windshields coming off of trucks to actually smashed windshields when the rock came back at a higher velocity, to multiple vehicle accidents with serious injuries. And I can attest, as my wife can, we were involved in the vast majority of those as EMTs and ambulance drivers. So I heard a lot of statistics about safety and truck traffic. I can speak, my wife can speak from personal experience. It is a fact that we lived with for 11 years. We spent a lot of time researching where we were going to move, and Rapid City was one of the places my wife researched. Long story short, we came here and within 2 days decided this was the place we wanted to live, purchase property, and spend the rest of our lives. It's like we're living in our vacation place. In my mind, 16 south of Rapid City is a brilliant diamond for Rapid City. It is great scenery, easy highway to drive, and a lifeblood for monuments that don't exist anywhere else, obviously in the United States and in many cases in the world. It's my opinion that it is part of a very positive experience, not only for visitors, but for the people that live in the area. It's part of the ambiance. It's part of a draw, part of being very happy and satisfied in living in such a beautiful area with fine people and magnificent activities, indoor and outdoor, and scenery. It's also my opinion that this mining operation is totally incompatible with the diamond. You are risking, in my opinion, the brilliance of that diamond, the positive experience that visitors and residents have by the truck traffic, which has been documented by previous speakers, in terms of people coming here for a positive vacation, relaxation experience, and being significantly inhibited or fighting traffic, heavy traffic that causes chipped windshields, smashed windshields, and automobile accidents. So I think my bottom line is approving this permit would have a very destructive, if not catastrophic, negative effect on the values and the attributes of the diamond we have on South 16. Thank you.
Thank you.
DTERR.
Okay, that would be Doug Tennyson.
Yep.
And
Okay.
my son Austin is next. We're both going to yield, but we are opposed.
Okay. You got about 4 letters of your name on there. Thank you. Let's see, Marilyn Oakes?
I want to thank the commission for hearing all of us and myself in particular today. I am a third-generation tourism family member. I have been driving Highway 16 since I had my first driver's license. I have some strong feelings, and much of what I wanted to say has already been said, so I'm going to take a little different tack. Although I have to bring up my grandfather who with Senator Peter Norbeck laid out Iron Mountain Road, and it was intentionally laid out windy and slow so that people would be forced to slow down and enjoy the beauty of the Black Hills. I can't help but wonder what Peter Norbeck would say if he knew we were considering heavy industrial activity along Highway 16, which takes us right into the Black Hills. My main thought, though, today that's different from what everybody else has said is for you to think about property owner rights, because this is actually boiling down to the rights of Kroll to operate business on the property that they own. And I would like to point out that my rights as a property owner end at my property line. If I were to engage, even though I'm living in rural Custer County or my property that I own in Keystone, if I were to engage in any activity that overflowed my property to my next door neighbors in any way, shape, or form, I would be infringing on their rights. And I don't see how this mining activity can not infringe on the rights of the people who own property in the area. We've already seen excellent examples of how that's already happening. And there are so many good reasons to look at this as a property rights issue, because while I do not deny that everybody should have rights to use their own property, if the use of that property is in some way or another damaging other property, then that has to be discontinued. I believe that you, Pennington County Commissioners, have the responsibility and the authority to take a position at this point and not allow this to move forward, even though today's hearing has to do with drainage, et cetera, et cetera. If we continue allowing Kroll to operate, I think you're doing them a disservice, as well as doing the property owners in the area a great disservice. If you don't act on this, if you do, in fact, continue to pass it along through the various agencies that are involved, we could end up with heavy industrial activity on agriculturally zoned property. That could lead to future boards having to deal with, well, we've got a heavy industrial mine down here, why can't we do this a little further up on Highway 16, et cetera, et cetera. I know you may have heard something that sounded a little bit like it could have been a threat, that there would be more public to do over this if it continues to move on. And I hope you don't look at it that way. I hope you recognize that there are a whole lot of people who are extremely concerned about this mining issue that's going on. And if we don't stop it now, I don't believe you are being fair to Kroll, and I certainly believe you're not being fair to the property owners and the people who have to drive Highway 16. Until or if there is ever any kind of resolution on how to get those trucks across 4 lanes of traffic safely on a hill that is 65 miles an hour, I don't see how you could possibly allow this to go forward. I really appreciate your time and opportunity for the rest of us to speak to you today. Thank you.
Thank you.
Ms. Holly. James Albert. Yield. James Bellato. So we got one more.
Good evening. My name is James Bialotta. I know a little bit about aggregate, being a former contractor myself. Ag is designated able to take aggregate to allow ranchers and farmers to collect soil and gravel to maintain their own private roads and entrances to fields. So what is aggregate? Aggregate is typically defined as small stone which has to be half the diameter of the thickness of concrete. Given the range of concrete being 6 to 8 inches, we're talking stones that can't be any larger than 4 inches. That being said, if the stones are 4 inches, you'd be able to scoop them up with a bucket truck, a hoe, whatever. Obviously, you don't need a blast. What they're doing by the pictures is blasting hard rock and creating aggregate. by definition, is an industrial activity. Either by taking the large rocks, taking it to a crushing plant is an industrial activity, or crushing them by use of blasting, machinery, or other means on the site, they're already violating the use of their zoning as it is. Not only should they not be allowed a permit to further violate their zoning, they ought to be issued a stop work order. And if they can't show that everything coming off that property is less than 4 inches naturally out of the earth, well, Homestake Mine would have been an aggregate, because they're blasting the rock deeper down and all the stuff they're bringing out is less than 4 inches. So are they really only collecting aggregate, or are they creating aggregate by use of machinery or blasting? So that's the biggest debate. So are they already in current violation? And if they are, not only do they not get this permit, but they get a stop work order and called into zoning asking why they are currently violating their zoning. I happen to own a shop that is located on Sturgis Road across from proposed peat lean pit. And I had to rezone my property, and I looked up all the different landowners. All their land is zoned heavy industrial. Nobody has ag and is doing any kind of blasting that I know of. I've never heard of a rancher blowing up cows, but maybe it's something I haven't heard of. So if it can't be crushed or blasted or altered out of the earth, then they're not collecting aggregate. Or they'll have to show us what they're doing. But already by the video I've seen, blasting would show me that they're not scooping it up with loaders or bucket trucks or something similar, that they're having to break it down just to load it up. If that's the case, it's not aggregate. They're creating aggregate. Thank you very much.
Thank you.
Your number 26, HMARLN? Marlowe? Is that Jim Marlowe? Nope. Okay. How about if we go on to the next one and he can be? No, sir? Nancy Berger? Let's see. Leland Shep?
I'm going to yield my time.
Thank you. Gail Greeninger?
I'll yield my time to another person.
Okay. Abelina Murphy?
Good evening, it's Evelina Murphy.
Thank you.
My husband and I live on Neck York Road, and I'm here to protest the expansion for two reasons. First of all, our community should not be punished with the burden of this company's poor financial choices. It was stated in a previous commissioners meeting that Corel has spent several $1 million for the purchase of this land. They should have evaluated what they were getting into before they made that purchase. Second of all is the safety issue, in the fact that when and if the future accidents happen, but when the accidents have happened on 16 and they block Neck York Road, which is where we have to turn onto to get to our home, then it means either sitting on Highway 16 for a length of time until the traffic can be rerouted. If there's an opportunity to reroute before then, it means going, returning back on Highway 16 to the Catron Boulevard cut across, taking that all the way across to Highway 79, taking that south again, and then coming back across on Spring Creek Road to get to my house. That's roughly another 25 miles. Minor detail to some people, but it's a big detail to me and my husband. So, safety issues notwithstanding, there's extra mileage that shouldn't have to be a punishment to me. Thank you.
Thank you.
Mick Harris? Gail Schmidt.
See which one of these works. That work good? Okay. Good evening. My name is Gail Schmidt. I am the Rockville Volunteer Fire Chief, and I'm here on behalf of the Volunteer Fire Department as well as the Rockerville Rural Fire Protection District that covers that entire area. You've seen maps before, and actually I'm going to steal somebody's presentation here just to bring up that map. Come on. There.
Ms. Gail, what fire department again, please?
Rockerville Volunteer Fire Department. So we are located just up the hill, just west of this current location. So from this map, you can see actually the big curve on 16 that goes right around this proposed enhancement of mining. Everybody so far has addressed quite a few of the issues, and including traffic accidents and an increase in traffic and traffic accidents, the blasting that will occur, and the aggregate that flows across the highway potentially. And those are some of my key concerns as well from the volunteer fire department's perspective. Highway 16, as everybody else has specified, is a 65-mile-an-hour zone. I guarantee you that a large number of people, especially going downhill, are not doing 65. If you've stood on that highway when an accident has occurred and had a lot of these trucks and vehicles fly past you, you feel the speed, you feel what's going on. So my concern from a traffic perspective is, if we have an increase in accidents, that means we're going to have an increase in the number of times that our units are out there on that highway taking care of those incidents. From a national traffic incident management class that the DOT puts on, an injury crash on average includes 2 law enforcement, 4 fire and rescue, 2 EMS, as well as 1 towing and recovery. I will tell you that on a large number of accidents that we have in that particular area, which by the way is the highest area of concern for me because of the steepness of the hill. So you've got the steep coming down one side and steep coming down another. It's difficult to stop traffic flow in those areas. You're putting a large number of people at risk just to go take care of that incident. If it's a fatality or a potential fatality incident, you'll see an increase in the number of law enforcement that we have out there. You'll see an increase in the number of EMS personnel that we have out there. If we have to bring search and rescue, there's another 4 to 6 individuals. If our fire department's there and we've got a large amount of traffic, it's not just the 4 fire rescue people, it could be 8 to 10. We have these things that we call BRTs, the big red trucks. They're great blockers, but when it comes down to a large semi or a truck hauling gravel or a 2-staged semi, I guarantee you I can put that semi up against my BRT and we're going to lose. Okay, so the ability to be able to stop these large vehicles coming down that hill is a difficult thing to do. Thankfully, in my time frame out there in the last 22 years, we have not lost anybody. However, on average, over the past 24 years nationally, over 80 fire, EMS, tow, and DOT individuals were struck and killed in highway incidents. So I would prefer not to be put into that situation. And again, with these large trucks coming up and down the hill, that will increase our risk for being out there on the highway. My other concern that you saw from the video, the amount of aggregate that would float across that highway. I mean, our strong winds come from the north-northwest. And if we get a blast that blows across that highway, what's it doing to the visibility of those vehicles on the ground? We could have a temporary drop in visibility, which again, could cause accidents. Is that being deposited on the ground? Is the highway wet and now that aggregate's being deposited on the highway, and again increasing the hazard on that highway and the potential for accidents out there. I will tell you now that with the current mining that we have at the Pearly Pit, we also on average, up to 10, 15 times a summer will get paged out for false alarms due to smoke. As you see that blast, most of the people in this area understand that there's blasting occurring and probably won't call that in. However, a tourist coming through during the summer would see that, and they do see that, and they call 911. to report a fire or a possible fire. We get paged out for smoke in the area. Again, that pulls our personnel, that puts our trucks out on the highway and creating, continued, anytime we put trucks on the highway, especially if we're running lights and sirens, it's a threat to those that are out there. It's documented, and so we're just increasing the potential hazard out there on the highway at this time. When you see that large corner that's out there, we had an accident just the other night. It is difficult to give the proper warning on that corner to slow traffic coming around that corner. Currently, we put cones out at 65 miles an hour, one every 65 feet. 5 cones, that's about 350 feet. That's the warning that we're given to the individuals that are driving through on that highway. With that corner, it's difficult to give a good, solid warning that there's an accident ahead, which means I need to put more personnel out. I need to put additional signage out to warn individuals that we actually have an incident on that highway. And the other statistic that I have for you is that for every minute, actually, that a lane is shut down on the highway, there is an increase of 28% of a secondary crash. So we typically shut down at least one lane of that highway. If it's a significant crash or a potential fatality, I have to shut down both lanes, which means that either A, we're preventing our individuals from getting through and they have to take alternate routes, or my less preferred option is to split the other 2-lane highway into a 1-lane highway, again, increasing the threat of the individuals that are out there on that highway. Most of our crashes take anywhere from 1 to 2 to potentially 3 hours if it's a serious crash, and therefore we're increasing that opportunity for a secondary crash out there in the area on this highway. So those are my concerns from the volunteer fire department, and I ask that you take those into consideration as you think through this whole enhancement. Thank you.
Thank you.
Anyone else for opposed? That's it. Do we have anybody else that's opposed that wants to speak? This is your time to speak, and then we will have the people in support. So if you want to speak, this would be your time.
Did you call this?
Yep, I did, sir. That was the lady that just spoke. So this is your time to speak, and this commission to listen to you. Jim Marlowe, you're here. Did you want to speak? We didn't catch you earlier, sir. Okay. Next is, in support, is Richard Plumer.
I'm the attorney representing Kroll. If there are some individuals here that signed up to speak as a proponent, I'll defer to them initially, and then I'll pick up after that.
There's just you and Kyle, sir.
Kyle?
Yes, sir.
Okay.
Larry spoke. Well, Larry was your friend earlier, but we let him speak already.
Thank you, Mr. Chairman, members of the commission. My name is Richard Plummer. I'm a member of the Brady Plummer Law Firm in Spearfish. I am the enormous legal team of Kroll Ready Mix. I would have had my partner here, but he's currently conducting operations in our Costa Rica office, and so he's not available today. Tom Brady, you may have met him. I've got some things that I want to talk to you about that I had prepared, but initially I just wanted to address a couple of the comments that have been made by the opponents. I don't know whether it will come as any surprise to them or comes as a surprise to you, but Kroll has not operated the Pearly Quarry. Anything and everything that you've heard about as to what has happened in the past involves another operator. The property, when purchased by Kroll, was under a lease that ran through March 1st. And because this hearing was scheduled, we discouraged Kroll from stepping in and undertaking any operations. So to the extent that some of the speakers have provided videos, to the extent that they have provided slides, to the extent that they have talked about runoff or other inappropriate activity at that site. That is not Kroll ready mix. And I think it's important because I don't want to be associated with what has happened in 30 or 40 years of mining in this location before Kroll has had a chance to undertake its first operations. One of the speakers put up a map showing what the extent of the proposed mining operation was. That was not a Kroll map. I'm not sure who prepared or edited that map. That is not a Kroll map, and I'll tell you very specifically, Kroll will not leave the property looking like that. Kroll has a practice of reclaiming as they go. You will not see the kind of map that that gentleman showed you. You've heard several speakers talk about 150 trucks per day. I may cover this a little redundantly when I get into what I've actually prepared to talk to you about. That is totally incorrect. That never came from Kroll. I'm not sure who the source of that information is, but it's misinformation, and to the extent that several of the speakers have provided you diagrams, information, calculations based upon 150 trucks per day, that is totally in error. The Kroll operation, when it was proposed, when they were looking at an alternate site out there, the plan was 15 trucks per day on a year-round basis. And that is the extent of the anticipated Kroll operation. There is room that that amount would increase during the summertime. And there could be periods of time when there is greater, substantially greater traffic than the 15 per day. It will never approach the 100 or the 300 that some opponents have thrown out there. The quarry could not conceivably handle that kind of capacity. So that's just misinformation. And I'm hoping that you'll give me a good listening to, because I do want to bring it back down to the real issues that I think your planning and zoning staff and your state's attorney have indicated when you hear an appeal of a construction permit. I filed with, or will file with, the commission. I don't know if I should be giving these to you or to Jay. An objection to you hearing this appeal at all. It is my position as Kroll's lawyer that the Planning and Zoning Commission and their staff acted totally properly in investigating, conducting hearings, and considering the construction permit under your ordinances. These are not Kroll's ordinances or anybody else's ordinances. They are Pennington County ordinances. The appeal does not cite any irregularity, any error in any activity of either your Planning and Zoning Commission or your planning director or any of the Pennington County staff who have been involved in receiving Kroll's application and acting on Kroll's application. Your construction ordinance, as Mr. Alderman pointed out, does not vest authority either in the Planning Commission or this commission to address about 90% of the issues that you've heard here today. You will find attached to the staff report references to permits obtained by Kroll from the Department DENR and from the DOT. And I'm here to represent to you today that Kroll has obtained every permit that is required for the conducting of mining operations in this location. If I can have those, Wayne. So what I'd like to file with Chairman, if I may, is first of all, the objection that I filed to the hearing itself. And then I have 3 other exhibits that constitute all of the active permits that are applicable to the Kroll application. Thank you. With me, I just want to talk a little bit about Kroll. As I said, Kroll has never stepped foot in operating this mine. But with me today are some really good people from Kroll. I have Kyle Freisinger, the aggregate manager. I have Christy Shamley, the environmental coordinator. Brian Marchant is the general manager for Western Operations. And also with me is Matt McPhee, who's an aggregate manager for Kroll. To the extent that there are technical questions that are over my head, and many of them potentially will be, I'll defer to one of the experts to be in a position of answering those questions. I just feel like the speakers in the past have given Kroll a bad rap before we've even had a chance to take possession of the mine. Kroll Ready Mix is a second-generation family business. They operate in 80 locations in 6 states. In this region, there are 38 locations and approximately 200 employees. Kroll has a full-time office and staff in Rapid City. We make no bones about it. They're a major supplier of aggregate to both construction and governmental interests. Pennington County operated this mine or had an operator on its behalf for approximately 20 years. The Department of Transportation operated this mine or had it operated on their behalf for another 10 or 15 years. Pete Lean & Sons has operated in this location. There have been several other significant operators that have run the Pearly Quarry for the last 30, perhaps even 40 years. I'm not limited to 5 minutes, as I understand.
No, sir, he gets the same amount of time as what we said when we set the meeting, as Kroll does as the support, as the opposed, yeah.
I guarantee
Just
you
to
I
be
won't
fair.
take an hour and a half.
Just to be fair,
It's
folks.
going to be 72 minutes in total.
Yeah, you can cut me off long before then. Kroll has conducted mining operations in South Dakota for 20 years. There are 2 notices from the DENR of concern regarding their mining activities. There's never been a violation. There's never been a stop work order. There's never been an interruption in South Dakota of any Kroll mine. One of the speakers spoke about violations in other jurisdictions. I don't know to the extent that I'm comfortable speaking of other jurisdictions and what their regulations and controls were. I will tell you that Kroll has addressed every issue that is raised in any jurisdiction. They have immediately come into compliance with any questions that were raised by any of the affected agencies. There's never been a stop work order issued. There has never been a suspension of any mining activity in any of Kroll's operations. So they're a good neighbor. They're a good business operator. They're a good mine operator. They're a good corporate citizen. They're bonded. We've got a regional office in Sundance. My analysis is, what is the appropriate issue before you? And Mr. Alderman will tell you if he thinks I'm in error or not. I think there's a single issue that is in front of you. Did the Planning and Zoning Commission err in determining that the application for Kroll Ready Mix complies fully and completely with your zoning or your ordinance relating to construction permits? If any speaker has pointed you to any term or condition of your ordinance that Kroll has not complied with, or any condition placed upon Kroll through this construction permit that has been issued, not a single speaker has addressed that. Now, I wish I could tell you that I had the answers to all of the other issues, but it's a very, very narrow focus, a very narrow issue that is before you, and as attractive as it may be to listen to a lot of people who really want to restrict mining in this location, I can only say that that horse was out of the barn 30 years ago, 40 years ago. It wasn't a Kroll decision to mine in this location. It's probably predates your zoning ordinance. So the issue of whether there is a mine in this location is not an issue that's properly before you. To say that you need to shut it down gives rise to a whole lot of other potential issues. So to the extent that you stay focused on what your legal counsel and what your planning and zoning staff have properly laid out as the criteria, and that is stormwater management, minimizing stormwater pollution, minimizing runoff and reducing runoff leading to soil erosion. Kroll has a plan that has been presented to your Pennington County Planning and Zoning to address those issues. They have a similar permit that was the application that was sent to the DENR. The Pennington County Planning and Zoning Commission have determined that they are satisfied with that stormwater management plan, erosion, sediment control. Department of Energy and Natural Resources, Environment and Natural Resources in Pierre has also issued its permit on the larger scale stormwater permits. So there is no issue of erosion or sediment control that has not been addressed and fully satisfied with both your agencies and the state agencies. And I'll politely ask you not to substitute your judgment for the judgment of those people who have jurisdiction to make those determinations. Second question I raised is there a proper appeal to this commission? If there were an appeal that identified an error, an oversight in the planning director, planning commission, and staff review of the application of Kroll, improperly considered that application, failed to do their due diligence, or issued a construction permit, and the construction permit is issued, if that was done in error, then it is incumbent upon the opponents to point you to something in your ordinance that would give you the jurisdiction to reconsider what planning and zoning has already determined. Instead, what we have are traffic safety issues. I think there were 14 speakers that raised the issue of traffic safety. Your staff consulted with the Department of Transportation to determine whether there was a safety-related issue in Kroll's mining operation in this location, given the amount of traffic that Kroll proposed to put on the road. The DOT, to the extent that I understand it, has indicated that at current operations, there is not a concern by the DOT. DOT made clear to Kroll that if there was a substantial increase in traffic arising out of this mining operation, that DOT would retain the right to revisit Kroll and discuss and review with them any concerns raised by the DOT. The proper venue, the proper jurisdiction to address issues of traffic safety on a state highway is the State Highway Department. I don't believe that Pennington County, with all due respect, has jurisdiction to control traffic and traffic safety issues on highways that are under the jurisdiction of either the Department of Transportation or the Federal Highway Administration. And I know I did actually sit as a county commissioner in Butte County, so I know commissioners don't like to be told that you might not have the authority to do what people are asking you to do, but I think those are the facts. Issues were raised on water access, quality, and safety. Again, those are within the purview of the DENR. Raised the appeal document raised a question as to the impact on tourism, and I just don't know that where to go with that one, because that's it's a property rights issue, it's a tourism issue. But what I will tell you, in that the 30 or 40 years that this mine has been in operation, it certainly has not slowed development of tourism-related traffic, tourism-related business, anything related to tourism on Highway 16 south of Rapid City. Many of the businesses that are located there, located after this mine was active. Many of the businesses that were up on the screen there in proximity to this area, and Bear Country is really the only business that is in close proximity to this operation, and I can represent that Bear Country does not oppose our construction permit. Bear Country is the only one that has any possibility of being immediately impacted. Expansion of the businesses, location of the businesses, new businesses, old businesses expanding, all of that has been done while mining activity has progressed on this site. So I'm having a struggle thinking that this mine has had a negative impact on tourism, given the, I don't know what the figure was, 3.5 million tourists that visit Rapid City and go south on Highway 16. Every department in Pennington County having oversight of any aspect of the construction permit was consulted. There were no, to my knowledge, there was no negative feedback from any Pennington County department, and I think their comments are contained in the staff report, which I suspect that you have. I want to touch on traffic just a little bit, because I think there's a misperception of what level of activity Kroll proposes. I'm telling you 15 trucks per day year-round. Higher in the summer months. I'm not going to rule out the fact that if Pennington County or the Department of Transportation have a road project that is on short notice and needs a bunch of gravel in a short time frame, Kroll is going to do everything that they can to supply those governmental entities. The information I gathered from the staff report, and I'm sure staff will correct me if I'm wrong, is that in the accident study that was provided, I believe, by the DOT, but it was contained and referenced in the staff report, there is not a single accident at the approach site to the Pearly Quarry. There are accidents up the road, down the road, a lot of deer-related accidents, a lot of tourists crashing into each other apparently, but none of those accidents are occurring in the actual location of the Pearly Quarry access road. And there was not a single accident reported in the report that I reviewed that involved a truck carrying aggregate, whether going north, going south. I mean, these people, certainly Kroll, but I suspect prior operators, are engaging licensed commercial truck drivers, And the consequence of that and the management of traffic at that location says that there's no trucks and no aggregate trucks involved in accidents and no accidents at the actual site. Discussion about blasting. Again, I don't quite know where to go with that. Whatever was showing on the video that was being presented was not Kroll. Kroll did not in February have possession of the site, was not operating the site, had no active involvement at the site. We were advised also that no blasting occurred after December 26th of 2015. So I'm not sure what that video purports to represent. It certainly is not Kroll. It's certainly not Kroll blasting. Yeah, laugh at me if you want, but you can verify that with the current operator. There's been no blasting at that site since December 26th. Blasting is, however, an element of aggregate mining. Their blasts have occurred historically for the last 30 years. And to my knowledge, other than the one that was filmed, I don't know if any of those concerns have ever been brought to your attention. I don't know if any complaints have ever been filed regarding prior blasts that have occurred on the property. Bear Country tells us that they are, as our next door neighbor, unable to determine when a blast takes place. Kroll uses, will use, a licensed independent contractor certified by the Bureau of Alcohol, Tobacco, and Firearms, specially licensed to conduct blasting operations. There are no explosives stored on the site. There will be blasting, generally maybe once a month, possibly twice a month in heavy activity. But there is no reason to think that problems going forward are going to be created when there apparently were no problems reported from prior blasting operations. Certified seismograph units are used, noise is measured. This type of mining activity is just simply a part of aggregate mining throughout the western South Dakota, eastern Montana, I mean, essentially wherever you find a quarry like this. So we're not inventing the blasting operation, but I don't think you'll find any more responsible party to take responsibility for those actions more so than Kroll. Argument was made about whether Kroll is required to obtain a mining permit. I believe it's under 507B. As I said, I don't even know how to respond to that. That was an issue that if it was going to be raised, should have been raised 30 years ago, 40 years ago. Kroll bought a validly existing, legally operating mine. Whether it was a permit was required in the early days of those mining operations or not, I can't speak to that. But we bought an operating mine. What we need is the construction permit because we are going to be disturbing 1 to 2 acres per year of topsoil. And so all of the runoff, all of the erosion, all the stormwater issues have to be addressed because we are removing topsoil and stockpiling and revegetating older areas. And we are and will be in full compliance with your construction permit requirements, your construction ordinance, and the regulations of the DENR. I think if I go too much further, I'm going to be repeating. So I'm going to tell you, right now, with no construction permit in place, Pennington County has essentially no jurisdiction over that mining activity. By issuing the construction permit to Kroll, you will have far more control over construction activities at that site than you have had in 30 or 40 years. I want you to also keep in mind that a construction permit is good for 1 year and is required to be renewed on an annual basis. Under the terms of your ordinance setting the standards for construction and enforcement of the construction permit, your planning director has the authority to issue stop work orders. You gentlemen ask why that's not done now. There is no authority under which you could issue a stop work order because there is no construction permit and you essentially have no jurisdiction currently over that mining operation. So Kroll is handing you jurisdiction, handing you the opportunity to control every aspect of the mine as it relates to construction activities, the conditions set out by your Planning Commission staff, incorporate as a condition of the construction permit that Kroll remain in full compliance with all DENR requirements for waste, air quality. I will also tell you, speaking of air quality, that every piece of equipment that Kroll operates, will operate in this location is also certified by the DENR as also meeting all dust and emission standards. What I can't address is the aspect of the prior arguments that it's okay to mine, it's okay to blast, just don't do it in this location, just don't do it where I can see it, just don't do it in a way that affects me personally. You've had those issues before you, I suspect, time and time again. Kroll is a bona fide business owner, they're a bona fide property owner. They bought a validly existing, lawfully operating mine. It is not up to Kroll to be penalized by any delay in issuing this construction permit. Significant financial losses will occur for any delays that are incurred. I've stood up at enough meetings, and sometimes I know when I'm not going to be successful in stopping the activity that's going on. So I've used that tactic myself. Let's just delay it. Let's wait for one study, and then let's have that study studied. And if there is a legitimate aspect that has not been studied, it's not part of your construction permit requirement, because anything that needs to be done to meet the criteria for your construction permit has been done. Anything that's required to be performed on a state level has been performed, and Kroll remains in good standing on all of those issues. I hope you'll reaffirm the decision of your Planning Commission. They put a lot of work into it, took a lot of testimony. As you can see from the thickness of that staff report, I don't think there's anybody that didn't have full and fair opportunity to provide input on that study. And all of the issues that relate to the construction permit were fully studied, fully reviewed, fully approved. And I just ask you to support your Planning Commission. Thanks.
Thank you. Okay. Commissioner, are you ready to?
One more, sir.
Oh, I'm sorry.
Kyle Frissinger?
Wish to yield.
Okay. Now, sir. He yielded, and that would be our last
Okay.
one. Thank you, Kyle.
We'll close this to commission discussion, and if commissioners have any speakers that they wish to ask questions of, call them by name and state your question. And if your name is called in that regard, then please step up to the podium and respond to the questioning commissioner.
Mr. Chair, before we start, could we clarify that, I keep hearing from the opposition that, or the supporting party, that this hearing of this appeal is not legal, or maybe that's not quite what you're saying, but I would like to know if this hearing's legal, because I can tell you from being on the city council, this has happened a lot. So, but let's hear it from Jay, if we could, to make sure this hearing that this commission is hearing today is legal.
Jay Alderman with the State's Attorney's Office. It's my understanding that the objection to the appeal that was submitted by counsel for Kroll was really intended to preserve their rights if a further appeal were to be taken. In other words, I didn't understand that objection to the appeal to be the equivalent of a motion to dismiss. So I don't know that Kroll is asking for you to dismiss this appeal hearing.
That's correct.
So tell me exactly what we're saying, because I kept
In my
getting.
opinion, this is a valid hearing. I don't think you're being asked to not conduct this hearing.
Okay, thank you for.
Council, I might disagree, at least in part. My position, Commissioner Hadcock, is that you do not have jurisdiction to hear an appeal of issues that do not arise out of the issuance of the construction permit. It is the construction permit that is purportedly appealed to you. And to the extent that there are issues related to the construction permit, I concur that you have jurisdiction to hear and consider those issues. I have objected to issues that go beyond the scope of the construction permit that relate to matters in the jurisdiction of other parties. Is that, you may or may not agree with me, but at least you understand my objection.
So this will be happening, and we will, it sounds like we're going to have an appeal, and we will speak. So on our behalf.
I'm confident you'll make the right, I'm confident you'll make the right decision.
Thank you, sir.
Okay,
Mr. Chair, if I might follow up, a need for you two guys to square away in my mind. You're saying two different things, in my mind anyway. You're talking about the particulars of the permit, and I think our state's attorney is talking about the interpretation of the statute or the ordinance. Am I correct in that matter, Jay?
Well, I guess I would agree with Counsel that you're limited to the criteria in the ordinance for your decision. So Kroll is not saying to close down this hearing. They're saying conduct this hearing, but limit your decision-making to those areas that you have authority to decide this matter on. To go outside of that, then you're going outside the purpose of this hearing. And I would agree with that.
But that includes our discretion to decide if the interpretation that's been made prior to coming to us is correct. Was the ordinance interpreted correctly? That's to me is before us.
Certainly, that's going to be part of your decision, sure.
As opposed to the individual, this many wattles and this many whatever on stormwater, those particulars, those are not an issue at the immediate time. What's before us is whether or not the interpretation by our subordinate unit is correct. I think we have full right, we the five of us, we have the right, the discretion to look at the interpretation of that ordinance and see if it's been applied correctly.
I can't say that it is your ordinance, and you certainly have the ability to look at your own ordinance and see if the Planning Commission and the Planning Director, Planning Department did what they were required to do under that ordinance.
Have interpreted it the way we might interpret it.
The bottom line, guys, here is about a construction permit, and it is our jurisdiction now and what happened there, I don't follow what a planning commission does. I listen to what the planning director says and the stormwater director and everybody, George. But I'll interpret stuff, like you say, differently than they do because I think, for one thing, we have some things I believe they missed as well on 507A, but I'm going to stick to 507A. I'm going to stick to construction permits, and I think Richard is saying that. Your jurisdiction is in construction permits, and I think our jurisdiction, if in 507A says we can do performance bonds, we can do other things. I didn't hear that at the Planning Commission. What I'm saying is I'm going to stick to 507A, George, and I'm past the Planning Commission. I understand them. I appreciate everything they did, but this is the Board of Commissioners now. We are here to an appeal, a decision, and then sometimes we find more statutes and more things in a decision that maybe they missed or that we can interpret like performance bonds and other things that this commission can do, I believe, a little bit differently and still stay within the law of a construction permit because it says it in 507A. So I'm past the Planning Commission. This is the Board of Commissioners. Let's move forward. Let's get all the information we need to make a good decision.
Okay,
Bottom
just a minute. Let's go back to the procedure. Does any commissioner have a question they wish to ask one of the previous speakers?
I do, Mr. Chairman.
Okay.
I have a question for Mike Mueller, if he's still there.
Is Mr. Mueller here? He's here, Commissioner Buskerud.
Okay, thank you. My question, Mike, is, you said you, I think, are from District 3 of the West Dakota Water. Are you representing them, or are you representing yourself?
Myself, just stating that I'm a member of that board.
Okay, thank you.
Any other questions? Okay, thank you, Mike.
Mr.
Does any other commissioner have
Mr. Chair.
specific? Yes.
I'd like to clarify with our Planning and Zoning Department, we haven't had any active construction permits going on out there? I mean, that's what I heard, and I'm concerned about that.
The best of our knowledge, there's been no active permits out there other than conditional use permits temporary for bituminous paving. There's continued access mining out there as of your meeting the other day with some highway proposals that you guys approved. So, but it is correct, and I've said it before, the Planning Commission this would give the county the most oversight it's ever had on this property.
And why was that?
I'm sorry?
Why haven't we?
I do not know the answer to that.
So I still have.
Question, I think we're all saying it. Who is doing the mining? I see it every day. I see the smoke, I see the whole thing, I feel it. Who's doing it if Kroll isn't doing it? Why can't anybody give us that answer?
There are several mining companies that have permits to mine in that particular site. And I don't know which one on any given day.
Maybe they should be here.
So,
Okay, we'll go back to any other commissioners have any questions for any of its speakers?
I do for Richard, please, sir. What concerns me is that this mine has basically been kept into a 40-acre area, and is Kroll going to keep this area in a 40-acre area contained? Or are they going to move into the area they showed on the map that they are going to move into another 164? How does that work? Does that make sense? Do you clean up the area you're in and then go to the next acre? Or I guess I've never watched mining.
Can I defer
action.
to our aggregate manager for
Thank you.
the answer? Kyle Freisinger.
As far as production versus reclamation, our goal is always to, for every acre we disturb, is to reclaim an acre. It's not always possible, but that's always our goal. That helps satisfy the reclamation concerns, helps keep costs down. So it is not our intention to strip off 40 additional acres and have any airborne dust of anything of that nature. Our goal is to minimize the disturbance and reclaim as possible as we go.
So it's not going to disturb, that whole area is not going to be a 204 acre picture like we saw on there, like Peatling Mine. That, your area is not going to look like that disturbed area there.
Our
You're
goal is
gonna-
always to reclaim as we take acres out of production.
Okay, and then also, Richard, you said there wasn't anybody else in a disagreement, and maybe we should have our fire department director, our fire emergency management is not in agreement as well. They are with the Miss Gail Schmidt. Concerns about the blasting and other things too. So, and I apologize, I should have had him here today. So,
And if I misrepresented that, I apologize.
right, there is concern with some of that as well. To me, it seems like before it was not a continual use. When I looked at the area, it was 55 tons was the most taken out of there per year. And now it's, how many tons are you going to possibly take out of there per year compared to what was there before?
The one gentleman that had the chart, I believe, the prior operators have been increasing their production at this mine over the years. And I believe the most recent figures that the gentleman mentioned by the current operator was 56,000 tons per year. That's where we're going to start. We do anticipate that there will be some modest increases, but it's a factor of what customers are out there, what demand there is for the aggregate. There are lots of aggregate plants located along the area. I believe conservatively, you should look at the potential for a 20 to 30% increase. So to the extent that there was 60,000 tons, you could easily see 80 or 90,000 tons gradually over a period of years. And that's why we visited with the DOT about, to the extent that there is any increase in traffic. What DOT has made clear that they never really defined when we reach the limit of when they begin to have more serious concerns, but they reserve the right to bring any serious concerns to us if we reach that point. But I also want to mention one thing. I don't believe it would be the practice of the DOT to shut any business down because of the amount of traffic that's generated. I mean, I understand we're talking 15 trucks a day and higher amounts during the summertime, but, you know, our traffic doesn't hold a candle to some of the tourism-related industries, including the large trailers and campers and motorhomes. But it might be an issue that at some point in time, some additional safety structures need to be in place. There may need to be some flashing lights, some warnings, some additional signage. We fully support and will address every safety-related issue that the DOT brings to us. And in most cases, Kroll will be responsible for the cost of implementing DOT-mandated safety measures.
Thank you.
Mr. Chair, I am still not satisfied with this answer of how much it's going to increase and how much area you're going to expand to. I think that that is one of the most concerning things for folks, is that they do not want that whole corner looking like a construction site. So can you be really specific as to what you think is going to happen there? Are you going to clear it off? You're kind of
Well, I hope that was made clear by Kyle. There's
No, you
going to be
danced
nothing
around that.
cleared off. There's
Yeah.
going to be nothing cleared off. The
That isn't what he
permit-
said.
The
All right, give him a chance to respond.
That isn't what was said.
The plan that was submitted to your planning and zoning
Have it here.
contemplates an additional 1 to 2 acres per year, with Kyle's representation that as new acres are developed, old acres are reclaimed. So in theory, and I'm not going to tell you that's going to work 100% of the time, but in theory, there should not be any larger operation than currently exists right now. I sense that there's some mistrust to that, but
Yeah,
I mean, that
there
is our plan, and
Well,
that's.
I'm looking at your
Okay,
maps.
just a minute.
That is also one of the reasons why you have the ability to review the construction permit every year.
But you just told us that this wasn't our responsibility.
The
a while
construction
ago.
permit certainly is. I think that's your only responsibility, but the construction permit is certainly within the control of Pennington County. We have to get it renewed by you every year. Your planning director has the ability to issue a stop work order if we violate any term of that construction permit or any condition that was attached to it. I really don't know. So, I mean, I'm not going to tell you that I have the crystal ball to tell you what's going to happen 20, 30 years from now. But each year, you have the ability to review it. And very honestly, if we cannot comply with any part of that construction permit, if we cannot comply going forward with all of the conditions of that permit, we're out of business. So, but to say that we're not even given a chance to operate legally, as your ordinance permits us to operate legally, because of some concern of what happened in the past or what might conceivably happen in the future, you have the continuing jurisdiction.
So, Mr. Chair, one of the things that I've observed, and this is my 10th year as a commissioner, so I've been through these things over and over. I just want to mention to you that one of the things that we do here in Pennington County is that we do have special meetings so that people can come and talk to us about their concerns. And I do not want any of you to think that that's not something we don't believe in. I know that every one of us up here does, and that kind of offended me, the way that you mentioned that before. So I want you to know that right off the bat.
I apologize.
Second,
I
I would
apologize
like-
for causing offense. I won't apologize for drawing to your attention the fact that there are matters that were attempted to be appealed that are outside the scope of your authority to
we're
address.
very aware of
Okay.
that, all right?
All right.
We have been
So, it's not my intent
definitely,
to offend. If I did, I
definitely
apologize.
told that. So here's what I'm going to say to you. Is Kroll willing, because I've seen this happen, where we do set up something like this, like a conditional use permit or something, the folks in the area don't like it, they will complain. A month after you get your permit, they'll be complaining. You'll be back in here. We've seen that happen over and over again. And so, are you willing to deal with that? Because
have
I
to.
think that's what'll happen.
We have to. Any complaint that's filed with your planning director, that planning director has the authority to do a site visit to determine whether or not we have failed to comply with any term, any condition of the construction permit, or any of the conditions of the construction permit. So
Yeah.
we have to deal with it. We're prepared to deal with it.
Okay, because I can see that happening.
To the extent that we can deal with it. What I can't deal with is some nebulous issue of are we affecting tourism? I don't know about that. And that's beyond the scope of the permit. Anything to deal with that construction permit, we understand it's going to be a fact of life, that we're going to be scrutinized. There's going to be inspections, there's going to be complaints. We've got, 3 or 4 different state agencies that we deal with. We obviously have Pennington County, we have the ATF, we have, this is probably one of the more heavily regulated industries in Pennington County. So we wouldn't be in the position if we weren't of the opinion that we can mine safely, and we can mine in full compliance with all the terms and conditions of the construction permit, and we know that if we don't, we've got to come back to you, or you shut us down. You issue a stop work order. You exercise the discretion, and Commissioner Farabee talked about some of the discretion that the commission has. There is the ability to exercise significant discretion over our operations. Now, we ask and expect it would relate to the construction permit. But anything to do with that permit, you've got broad latitude, broad enforcement authority, and you will find that we are a good partner.
Sir, if I could, Mr. Chair, there's three things on here that, if we're talking about construction permits, construction permit, and it says number 3, construction permits and erosion control. It says during construction, soil is vulnerable to erosion by wind and water. Nobody ever talked about the air. Isn't wind air? Air quality is huge in mining or any, even my husband's construction company. So wind is air, and we've never, as a commission, and that's why I said, at the Planning Commission, it was erosion of soil and stormwater. I didn't hear anything about the air. Safety of blasting, that isn't a concern that had been brought up as a concern of, it was from a volunteer fire department, and that's why I went to our emergency management department, and I would still like to hear from him. And I'm not shutting that down. What I'm saying is I want to make sure he's satisfied as well with Pennington County and how we do business in this mining area as well. Because I remember too, when we did some stuff in the city and people were going to have safety issues with things or blasting or something, people actually alerted the neighbors. So people weren't thinking there were fires, and the fire department wasn't thinking, if you're going to do 2 a month, you see what I'm saying? There's certain concerns for me that are pretty simple in one sense, but they're a lot for these neighbors and the people that are doing this, or living in this area. And the other thing we do have on 507A is a performance bond. And I think it's huge for me to make sure that this, and it's page 177, sir. Planning director may, but now that it's to us, I think we may as well issue or want a performance bond to make sure that, we're not going to have that cleanup once you're done, or if there's any issues with that cleanup. And I know you guys have one, but legally it says that we can have a performance bond on this property as well. So.
Can I go back and take those one at a time? Or are you finished with your list there?
That's the first 3, but go ahead.
How do we handle dust?
As far as airborne dust is concerned? Is that the question?
Yes, sir. During blasting and then during construction, when you are moving and getting the aggregate out of the earth, sir.
Sure. Each crushing unit, screening unit, conveyor transfer point is regulated by the air quality permit by DENR. DENR has an office here in Rapid, and they're, of course, headquartered in Pierre. And everything is regulated with an opacity or a measurement of dust. And they are well aware of our location. We've had air quality permits in the state for 20 years. So each origin of dust is regulated. As far as airborne dust is concerned, it goes back to comment earlier about reclamation. Our goal is always to reclaim as we disturb. By reclaiming, by seeding, mulching, planting trees, whatever it's necessary to put the property back in vegetation, that helps mitigate any airborne dust.
Mitigate is the key term. I'm not going to tell you that I can control the wind. And I suspect even Kyle would have a problem with that. There will be dust. Dust comes from wind. You have dust currently. Wasn't our creation, wasn't our baby, it wasn't our project. We are looking to take a project and make it better, control the expansion, begin a reclamation process with the previously disturbed soil. But I can't, I'm not going to promise you that there's not going to be an issue that dust from time to time will blow off that property any more than it, I can tell you that's not going to blow off a racetrack or city streets or any other surface in the county. So hold us to a reasonable standard where the air quality standards can be controlled. Things beyond our control are a little bit different. Blasting standards, I don't think are a part of your construction permit. I would be reluctant to see you step into that issue, Commissioner Hadcock, primarily because the aspect of blasting is the actual blasting performance itself is an ATF regulated business. Blasting has been occurring for 30 years in that location. And this is not we will not be the first party to blast, but we will blast.
Can I address you with that? But they're saying now, before you're even there, that there's issues, and you said you wanted to be a good neighbor.
Absolutely.
So what I've seen in the past, sir, is when you're blasting, the emergency management people were notified, so if there was any calls or anything, because that's a lot of people out of service for your blasting. So I don't think that's a hard stipulation.
A good neighbor would suggest that
You know, even if it's not in here,
something that we should do, whether it's in there or not.
it's not hard to be a good neighbor, and we've done it in many things that we've
Give us a
done.
good contact person, somebody that can spread the word, and the phone call will be made.
Yeah, and to reiterate what Gail had said, I was a volunteer firefighter for Rapid Valley for 5 years. False alarms are a huge deterrent from the working people to go out and false alarms. Part of our being a good neighbor upon activity, meeting with our closest neighbors, meeting with agencies that we would depend on for support, a force of help, like Rockville Fire Department is common. If the fire chief had requested a phone call to either 911 dispatch or herself in place of to notify a blast, deter any false alarms, that's part of being a good neighbor.
Thank you. Next one.
The bond, I'd encourage you not to impose anything onerous. We are bonded. We have a blanket bond with the state of South Dakota for all of our mining operations. So the bond is already in place. It is there for the same purposes as what you've indicated.
But I've seen us, even in the city, even if you have a construction bond, meaning your own, we have asked for extra for the city because of some of the issues that might occur from more use of the land, is a good way to put it. So it isn't just in mining, sir, that we have done that. We're not picking on you specifically in Pennington County either.
I think you would. I mean, can you point to me any other mine in Pennington County or any other construction permit in Pennington County where you've attached a performance bond as a condition? If you can't, then you are singling out Kroll. But let me also say this, just from a very practical standpoint, and your counsel can certainly indicate if he believes I'm wrong, a performance bond lends itself to a short-term construction cycle where I'm building a building, and I can determine when I start and when I stop and whether or not the conditions of that bond have been met. That's where the performance bond technically and usually comes in. We are talking about a long-term mining operation that will change from year to year to year, and I think your best control, you will let me know if you disagree, your best control is the renewal of that construction permit and the enforcement of the construction permit.
Sir, I disagree. I don't know, and maybe I'm dumb and don't just know this, but you're on a hill. You're increasing it from 40 acres to disturbance of up to, not at the same time, you said 204 acres. maybe I'm wrong, but the areas that I've seen are pretty much on flat line. You're on a pretty good grade there.
Bond is in place, Commissioner.
Right.
So let's not argue. I mean, you've got your thoughts, and I respectfully disagree.
And you said
don't
I
think
could
a
use
performance
anything, sir,
bond-
in 507A, right?
Pardon?
You said I could use, in this discussion, anything in 507A.
No, I did not say that. I said what is appealed to you, what is appealed to you is the Planning and Zoning Commission's issuance of the construction permit.
When I've been a council person before, and it's not just you and your mining permit, sir, it was different areas in Rapid City that had concerns of erosion and sediment that were a lot higher than just regular construction. It's not you, sir. I mean, you're going to say that, but you can look back, and I have a record of that. So I'm not doing it because it's you. I'm doing it because I believe when you create a mud hole on top of a hill, no matter where you're at, if you're doing a building or a mine, there's concerns. If you're increasing it from a 40-acre to a commercial mine that might get bigger, as you say, maybe 20 more tons, there's a concern.
Maybe it's semantics. I don't think I have the same issue if there is a bond similar to what we post with the state that is conditioned upon compliance with the construction permit. I do think a performance bond as such is a different beast, carries with it a lot of different underwriting and carries with it a lot of different expense. So just maybe discuss the language that you might want to use on that with your counsel.
And I have, and I appreciate that, sir.
Okay.
The other thing, and I'm sorry, Commission, but I apologize. On 507B, here's what concerns me. You wanted heavy industrial first, and so that was shut down because the zoning didn't, we shut it down, didn't believe that area, or I don't know what we believed at the time, I can't remember either. So it looks like to me, this is my interpretation, this is not this council's. It looks like a construction permit, not a mining permit, but it says A1 Ag. Then when I saw A1 Ag, and I've been on a planning commission for a year and city council for 6, why would they put mining permit B in A1 Ag? And then I thought, well, it's agriculture, and why would that be related to agriculture? Well, there's sand and gravel and all that stuff you said. But it's also, I think the main thing in agriculture is what you're talking about is farmers and ranchers. People that might have wanted to put, let's say Lindell, maybe an acre or not to disturb, says right here, no extraction of every mineral or subject exceeding 100 cubic yards from this earth shall be conducted without a mining permit issued by the commission. Why would they even put that in there? That's your planning commission. Your variance board on the second part is us. We are the variance board. Why would they put that in there if it wasn't a concern on mining permits? I haven't figured that out yet, except that A1 Agriculture District for construction, which is agriculturally related. So
If you
I keep looking back at that, and it's not making sense, because when I'm looking at construction permits and this whole thing minimizing, it says minimal disturbances, minimal stuff. I've never seen anything where if you're doing some big digging, whether it's mining or anything else, that it's minimal and they put minimal on there. Unless it's something that's simple. And it's going to be constructed, done, minimal, and then it's good to go. Does that make sense?
I don't intend to be argumentative. We did
Oh, you
not
can, sir.
dig that mine. We did not dig that mine. Somebody with the advice, consent, permission of Pennington County mined and has mined in that location for 30 to 40 years. The kind of description that you're talking about, if we were starting from scratch, or on some of the adjoining property that was not already developed as a mine, clearly a mining permit would be required. But the mining has already occurred.
Well, Richard,
But I
without
also
being
look- excuse me.
argumentatively, and as you say, it was only 40 acres since 1982. Up to 55 tons is the most, sir, that I've looked in there, average 19 tons per year. So you tell me, sir, the difference about you and what you're gonna do, and you're not gonna call it an industrial, you're gonna call it and you said, and it says general ag. I talked to two people, and they said the Pertley pit was never meant to be anything but used for general agriculture stuff at the time, and then DOT and some other people started using it. And
Pennington
started
County.
mining it. And maybe I have to check that information more, but it's common sense to me, if you only took 55 tons out of there at the most, and that was 2015, but if you looked on average, it was only 19 tons. I don't think anybody was fully thinking at that time, which could be our fault, that it was gonna be a fully constructed mine at the time. I think the intent of the construction permit was for general ag, literally.
In 2015, 56,000 tons were mined. I don't have the memory to indicate what the history was, but production at that mine has gradually increased over a lot of years to the 2014 number, 2015 number, I'm not sure which is 56,000 tons. The only other thing I'm going to mention, Commissioner Hadcock, is we are bound by your ordinances, and I trust that you feel bound by your ordinances. But when we look at your definition of what uses are authorized in an agricultural zone, there is a very specific reference to mining activity with a construction permit. We've done our absolute best to follow the terms of your ordinance, and to ask us to go beyond the scope of the ordinance and determine what might or could have or should have been done in connection with mining at this location 20, 30 years ago, I can't even speculate.
Well, I guess you're using 507A to do it, and I'm using 507B to say it was done differently, and I have to prove that. But to me, it looked like common sense. But otherwise, you would have came for heavy industrial.
We had to come for a construction permit to operate a mine that has been historically and legally operated
Okay.
in your agricultural zone, I suspect as long as you've had an agricultural designation. And it requires us to obtain a construction permit. And Commissioner, I probably am doing a disservice to my client by having an argument, but we're complying with your ordinance. And we have complied with every element of your ordinance.
So, sir, in my mind, sir, we need to look at a performance bond and see if it's legal. We need to talk and bring for fact to you guys, so you're not guessing where our emergency management man is. If the wind or air quality, I'd like to look at the permits that we have, to be fair. I would like more time to look at all this and then just make sure that what we are doing is right as well. That's my opinion. I'm not ready to say I know everything about what you're saying, and I'd like to take all this information from everybody else and to see if it's fact or if it's not. That's what I've always done,
The only thing
sir.
that we would ask is that you do as expeditiously as you can.
Thank you, Richard,
Pretty
for
expensive.
answering my
Okay.
question.
It's a pretty expensive operation.
Any other commissioners that have questions that they want to?
I do have something about zoning. One of the things that I noticed about your property is that it actually has two different zoning areas on it. One is highway use, and one is the general ag. What happens with the highway use? I mean, are you going to have to, if you continue to expand or move around the property?
Right now, the highway use, little square highway use is not intended on to be disturbed, and it is not in the construction permit.
One of the things that I was concerned about is that it looked like in your application that on that highway use was where you were going to put your well.
Yes.
And I need to understand if that's the way it can be. I'm not sure about that. Because you're putting in highway use a well. but that well services your mining. Is there a reason it has to be there?
That was the site that we had chosen.
Okay. I want to understand that, and I worked on this for a couple of days now, and I haven't gotten a definitive answer. Our highway use doesn't say you can put a well there to service other businesses. And that is important to me, that I need to understand how you're going to handle that, because are you going to move through and, okay, you mine here and reclaim there and mine here and reclaim there, but then you're going to come to highway use. I mean, at some point, I would like to understand what we're going to do with that particular part of it, because it's a big part. It's a pretty good size of what you're going to be doing there. And I need to understand.
Yeah, the only thing is it was not included in the permit and is not intended on being disturbed.
Okay.
As far as the mining is concerned.
Okay, because I was understanding the whole piece of property was under, you were going to be using the whole piece of property.
There's a disturbance map that planning and zoning has that has not been indicated for disturbance.
Okay.
When do you take possession of the mine?
Current operator is there till the end of March.
So, I know Mr. Farabee had met with you, but I thought at this time that you, or by that time, you had called us or wanted to meet with us, and that's, and maybe you didn't think that was appropriate, but I think a tour of your place and then some of these questions as well could be answered, and it's still, if we didn't have the answers, at least we could look them up and be fair, because I have listened to many people in this issue. And it sounds like Mr. Farabee had met with you, but I always had in the past, both sides contact me and say, you have any questions, you want to come see your concerns, things like that. I think it's huge for us to be able to explain to the public and see what we're saying. At least it always has been for me. I have to see something in order to believe it or know that it's happening or that it's going to happen and how it's going to happen. So when they have concerns, no, I went on site. This is where the stockpiles, this is where this happens. Their well is over on highway service. They're having 20 trucks. This is where, it's easy for me to tell people that, and then in concerns for the next 3 years or so that I'm here.
I think we would accommodate a commission site visit. We did visit with Mr. Farabee and made that offer.
Okay.
I didn't do any politicking.
Nope, it's not for me
deal with-
politicking, it's
I
fair
deal, well,
business.
no, as an attorney, I think I'm limited to dealing with your counsel, and didn't feel it was appropriate to go over his head to deal with you directly.
Sometimes the planning commission, that's a little bit different sometimes, but I remember at the planning commission, but it's our job. So, thank you.
Okay, Commissioner Farabee, do you have any questions?
I do, yes, and a couple of questions. Before I do, though, I want to say for complete disclosure, I met with Kroll Ready Mix, 4 individuals, and the purpose was, I was tasked by this commission, by the chairman, to lay out a format for this meeting. I don't know about others, but the only way I can do a tasking like that is to meet with the folks that are participants. So my sole intent, meeting with Kroll, was to find out how they would like to have this meeting run.
Correct.
I want that clearly understood.
And that was a significant.
There was no intent on my part to gather any information other than how to run this meeting. Okay. Now, having said that, Kyle, you mentioned DNR air quality permit. Can you elaborate on that?
Each crushing unit is regulated by DENR. It's a permit that you apply for. Each portable crushing unit in the state of South Dakota for any operator has an air quality permit attached to it. The air quality has a attachment that has the regulations, how to move the crusher, forms that are necessary by DENR, inspection frequency, what have you.
And they issue that?
DNR issues it, yes.
How does that tie in with Rapid City's air quality and Pennington County's air quality program?
The Rapid City non-attainment zone was researched, and the City of Rapid City air quality permits were researched. That area is defined specifically by legal description to include certain areas of West Rapid City, a little bit into Meade County, and into Rapid City. This area of the mine, the Pearly Quarry, is outside of that defined area.
Understand that, and so there is, the oversight then comes from Pier.
The oversight for DNR, they have an office here in Rapid City and staffed with engineers, and the DNR is headquartered in Pier, yes.
And that permit is available to us.
You have it in your package.
We filed it.
We do have that, okay, and then, can you elaborate a little bit on reclamation? What, I know you don't have any real tight specifics, but can you give us a general idea of what you mean by reclamation? Just grass or grass and trees, or?
Typically, a lot of the areas we work, it's just grass. Native grasses, work with conservation districts to find out grasses that would grow in that environment, knowing that the plains is different than the Black Hills. I have been involved with operations. We planted trees.
But for that specific site, what, you got anything in mind yet?
Nothing in mind besides native grasses.
Yeah. And then Mr. Chair, one last question for Mr. Plummer. Section 507 says construction permits. Are you limiting your thinking to 507A or all of 507?
The appeal that comes to you is an appeal of the construction permit that was issued by your Planning and Zoning Commission. So my comments, my belief is that the appeal issue before you is limited to the appeal of the construction permit as it was issued by your Planning and Zoning Department.
And in your mind, that's 507A and B?
You know, I don't want to dodge your question. I was not involved in any of the Planning Commission meetings.
I understand.
You have a construction permit ordinance. You have standards for enforcement of that construction ordinance, and your staff, as far as everything I can determine, appropriately required the application and all of the materials that had to be submitted in support of that application. We provided those to you on your forms. We complied with all the requirements for verifying that the Department of Transportation had been consulted, DENR had been consulted. Your staff independently, I think, verified substantially everything that we provided to the staff and made a recommendation that was approved by the Planning and Zoning Commission. It is that construction permit that has been appealed to you.
And Mr. Chair, if I might follow up, from my vantage point, I don't know about the other four commissioners, but the section 507 says construction permits, and that's everything that follows, A and B. That's from my perspective. Thank you, Mr. Chair.
Mr. Chair, may I say one more thing? We've talked some about air quality here, and you referred to the Rapid City air quality. Well, Pennington County also was a part of that, and I want to do some research on that, because I remember our commission a few years ago, our county worked with the City of Rapid City, and we signed the same thing so that all that is applying to Rapid City applies to Pennington County. And I want to get
But it hasn't reached out that far yet.
Yeah.
But that's what Kyle was saying.
No, it is effective in Pennington County.
But-
So please let me say that I want to research that before I can say one way or the other, because I've been really involved in water quality and air quality. I have to tell you that I'm very concerned about Spring Creek. We've spent a lot of money trying to make it clean. And I want to make sure, I have some real concerns, and I'm going to look through those before I can make a decision.
I suspect that if we do what the gentleman thought might happen to Spring Creek, DNR and other agencies would have shut us down long before
But you haven't operated there yet, and we're going forward, and I want to make sure that we have a control there that keeps the danger of something happening to a minimum.
And I think that's the purpose of the construction
Yep.
permit. Understand you've got questions and you'll get your own answers.
Yep.
Commissioner Buskerud, do you have any other questions?
I do not. Thank you.
Any other commissioner?
One more thing. We had the DOT sit through all this. Do they have anything that they want to talk about? Only because
I got enough.
they've been here 3 hours and maybe they want to address something, and if they don't, she's shaking her head no. But I wanted to be at least respectful that someone would sit through our meetings, thank you, to see the concerns of the people, and Kroll as well, to make sure that they were taken care of, so thank you.
Thank you.
Okay, anyone else? If not, I think it's time to act.
I think we're continuing till, if that's my motion, till, what's it, March 15th is our next meeting, folks? That'd be my motion.
Is it?
Is there a second to the motion?
I'll second that.
Second.
I think we had 3 seconds. Vote. Okay, we have a motion and a second. Any discussion on the motion?
We'll try to get through all this material by the 15th.
Okay,
Thank you, Mr. Chairman. Just briefly, PJ mentioned to you early on that DENR could not be here today, but they would come back if you requested them to come back. So if you have questions specifically of DENR or their permitting that was involved, then I would ask you to include a request in your motion just now that they attend to answer any questions you might have.
Yeah, I think at that time with the emergency management, and we'll probably have a list by then, but we should have that disclosed beforehand so everybody knows who's going to be here. I think once you go through the material by the 15th, we're going to have more things that we're going to have questions on.
do you
or
wish
people
to
come.
amend your motion?
To bring more people here? I don't know how to make that motion.
Just to clarify, DENR specifically would like a motion from the board if you want them here.
That's why I said that.
Thank you.
They need you to have that in your motion in order for them to actually be here to do that, so.
Okay.
I appreciate that.
Is the amendment to the motion acceptable to the second?
Yes, but I guess I'll have to ask now, is that all of DNR or just one branch of DNR? In other words, there's the air people and there's the water people and,
Who did you need, George?
I don't know.
That's a good question.
Well, our director said that DNR needed a specific direction and
Brittany, who on this construction permit that could help us if we had questions on the construction permit from DENR can help us? How about that?
Sure, there's 2 separate divisions in DENR. There's one that would deal with the stormwater, which is under the surface water group, or the mining, which is the mine license, if you have questions about how they issue that. So
and then there's the air people.
that's under the mining. The crushing and the air quality is under the mining group. So if you want both, one, you would have to determine which one that you would like.
Both.
Well, okay.
That'd be my motion.
Okay.
George, that okay with you?
Second, yep.
Okay. Any other discussion on the motion?
Thank you.
Roll call vote.
Buskerud,
Aye.
Farabee,
Yes.
Adcock,
Aye.
Troutman,
Yes.
Peterson.
Yes. Motion carried. Thank you all for your courteous participation. And thank you, Deputy, for your patience and being here.
And their staff.
To adjourn, roll call.
Buskerud. He gone?
Go ahead. Go ahead.
Farabee,
Yes.
Adcock,
Adcock, yes.
Troutman,
Yes.
Peterson.
Yes.
Buskerud, yes.
Okay.
Wasn't paying attention.